Hello, hello, hello. This is Attorney Mike Garvin coming to you from Chicago as usual, and we're joining the trial right now. Let's do it.
However, he is wearing street clothes, a suit and tie, and a mask.
All right, it's quiet already.
Noted.
Yeah, it is.
All right, Mr. Brooks, just preliminary.
We'll make adjustments here. Let me see.
Anticipate calling any additional witnesses today?
For the record, I don't seem to being called that name. And what was the question?
Do you anticipate calling any witnesses today?
I don't believe today.
Then why are we
We're
here?
here for the continuation of testimony. The only witness that I'm aware of that's on your list that you added is your mother, Dawn Woods. So I would expect that if she's going to testify, she would be here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Oh, here we go.
Receive my ICS.
Oh, we're right off to the bat.
Well, I haven't looked. Let me look.
Good morning.
Good morning. Thank you. Mom's not there.
You and then one to the prosecution. Is the audio on?
It is. The audio's on.
Oh, I think they actually in the courtroom are having audio issues. I don't know if that's Lauren Grimes' problem.
Do you know when you sent those?
Saturday. So that would have been the 22nd.
When your mother won't show up to defend you, you've got serious
Did you
issues.
receive anything through like the inter-office communication?
We have not. I just checked this morning to see if there's anything new. Nothing has been received at my office. And I should say the clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
Jay, yes, I have no idea what she can defend, but her not showing up at all.
Anything in
It's a bad
transit,
look.
if there's no objection from the parties, from the state,
No objection.
from you, sir?
No objection. I definitely want those documents received if they obtain important information.
You said you forwarded them to a staff member on Saturday?
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe afternoon.
And those are two ICF forms?
Yep, one addressed to you directly and one addressed to
Okay, hopefully that's better.
But I need one whiskey.
John, just sit there and look pretty, okay?
I had somebody saying that I should shut up today, and I told them, you know what? Pound sand.
Oh, Australia already in the house. This is awesome.
Send it with high importance and we'll see what response I get. But I don't have anything. If you want to generally tell me the topic, we can cover it verbally.
the topic is pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
Right? What information make enough of proof for me, sir?
The
Yes, and I have it up based on that.
For the prosecution in regards to
Oh my God, he's actually making a Brady argument?
inspecting the vehicle. Officer Ryan Schultz.
It's almost like he learned some
Question
law.
was asked of did he know if there were any recalls on that vehicle? And I believe that
Oh, that sounds much better.
a Brady claim should be visited because there were, in fact, recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford Company were sued because of this, and those vehicles models from the year 2008 through 2010 were recalled. And that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained just by pulling it up, and you will see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to.
And he screwed
So
up
what's
his
your
Brady
request,
argument.
sir?
My request is to find out if Officer Schultz knew, to find out if prosecution knew that there was a recall on those vehicles. And
They don't have to do the research for you.
in light of
If you're saying that it's obvious,
The,
it's not a Brady violation.
the fact that these vehicles were recalled because of this malfunctioning throttle body.
Brady basically is
Or,
the premise that the prosecution has to provide
I believe
every
it's-
piece of exculpatory evidence over to the defense that they have available.
Counts
However,
173
because he's saying that
is
it's
mixed.
obvious to everyone, it's not like they had it and
All right,
he
what's the
didn't have
response from the
access
state
to it.
defendant?
Thank you, Your Honor. As Trooper Schultz
almost breaks his
testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony,
She's ready for it.
that Ford listed an extended warranty for the throttle body on the Escape.
Oh,
The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the
It's at
electronic
least a
throttle
legal
body
argument.
failures would have resulted in
I mean,
engine
I've been
stall
trying to find anything
or
from
surge
it.
while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been
Yeah, she was. I don't know
the
how she saw that
malfunction
coming. I
indicator
didn't.
lamp or the
But she's
wrench
ready.
light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle.
build up on the
electronic throttle
commutator.
body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the
I am
car that
very
the defendant
impressed
was
with
driving on
public
this day did
servants
not have that
of
problem.
Waukesha,
That was
Wisconsin.
testified
They're
during
on top of this.
the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety administration. There are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls. So it's a moot issue.
I don't believe it's an issue.
Yeah, I asked her what a
And
Brady
I actually
argument is.
have, the report should be in the mailroom as we speak. I had everything sent over priority mail, the actual information about the class action lawsuit, the actual information about the recalls for those models. Like I said, 2008 through 2010. Now, in all fairness, Your Honor,
The prosecution
why I
just
was
explained
asking
why that
for,
is irrelevant to this
Brady-
particular
Brady
matter.
claim on this. Seeing as how when vehicles
You
are
lose.
purchased from the
Good day, sir.
manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it
He's trying
actually
to argue that it was
happens.
mechanical failure, that it was the car as opposed to him slamming the
Yeah.
accelerator into a bunch of people.
Seeing it's a class action lawsuit,
Oh, we got Waukesha in the house.
no one would sue
Barb?
the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit
Yes, but this was
If
not a malfunction.
these vehicles were
Thanks,
not
Nate.
malfunctioning.
Oh,
And I believe with that, like I said, the information is easily obtainable. I should have the information in the mailroom right now, that you can readily view this information about the class action lawsuit, about the recall. On it wasn't just
It's
the
irrelevant to
2010
this
model in
case.
question. It was 2008 through 2010.
okay. Then they don't need to turn it over to you if it's
The
widely
information
available.
about the malfunctioning
Precisely. He's
pertains
destroying
strictly
his
to
own
the
argument.
throttle body.
Let me address
Call
your
for
claim,
it.
sir. So,
They inspected your
not
specific vehicle.
trying to cut
and
you
there
off,
was
I
no
don't need the
malfunction.
specifics about a class action because
Oh, God,
as
it's
it
too-
relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even
Yeah.
indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to
Thank you, Your Honor.
cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls. And more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email. It's one page with
David Edwards, he could
what you
ask. I
said.
think the
It's
answer is
to
going to
turn
be
my
no.
head. I gotta figure out how to flip it. So give me a second.
Okay.
Oh,
Just for the record, Your
Hold
Honor.
on, let me finish my record, okay? So I'm gonna turn because it's the only way I can read. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother. And from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information
covers it.
regarding the recalls and what to do.
she's giving a nicer
And
version of that.
presumably, she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone
Sure
else
appears
who
that way.
operated that did anything with it or not. The bottom line is there is absolutely no Brady violation
Mother
by the
wouldn't help
state.
because
This
the
is not the
prosecution
type
just
of
asked, did you
information
receive a
they
recall
would have
letter
been
and did you do
required to
anything?
turn
The answer is no.
over.
All right.
And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever.
Yeah,
so I'll deny the request to dismiss the case, and I'll deny the request to recall this witness.
Stupid oral motion denied.
Hold
Your
on.
Honor.
Next.
Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him and it was questioning, asking questions directly related to information contained in that report.
All right. Go ahead, Mr. Brooks.
When you spoke of the owner of the vehicle, that's who gave me the information. My mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the information. And she was the one that said, I'm going to send you all the information that you need so you can present it to the court. So I
understand that, sir,
this
but
wasn't
your request
information.
is not timely. So you have had this information for quite some time, either through
I
counsel.
did not have it for quite
Let
some
me make
time.
my record, either through
It
counsel.
was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not really readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm
and
telling
I'm
you, she just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
And I would like a.
So that's my decision.
I object to that, Your Honor.
I understand.
I
I've made
object
my
to that.
decision. I expect that you respect the decision, at least
No.
as we're not going to debate it further.
Yes.
I now have the
It needs to be-
ICF,
It
the
needs
one
to
for the
be
state to be
addressed, Your
provided
Honor.
for the state.
It
Madam
needs to
Clerk,
be
I just gave
addressed.
that to you. All right, so
I
Mr. Brooks, in
respectfully
light of
object.
that,
I respectfully object, Your
Yeah,
Honor.
we get that.
And
Thanks, Doug.
request the legal reconsideration of your ruling, Your Honor.
it's denied. The request for reconsideration is denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
On reconsideration, the
Mr. Brooks, we
reconsideration.
need to keep
That's
going.
not how anything
For the
works.
record, may I request a legal or factual basis for your ruling, Your Honor?
She just gave it.
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request
No.
is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
Oh, God, he's reading all this.
I wouldn't be the one you would make that request to, sir.
It's
So
time.
you
For the
can't
record, may I
answer that
move
yes
to
or
stay
no.
these proceedings until the instant matter is
We made it
adjudicated
20
by a
minutes.
court of competent jurisdiction.
20 freaking minutes.
Based on what law and fact, Your Honor?
The request is denied.
Based on what law and fact,
What,
Your Honor?
any other requests, sir? I'd like to move on.
Based on what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion. So it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor. Can you show me how or where this court is following the law and respecting this matter?
For the record, it appears this
That's a very
court is in
vague
contempt.
statement, sir. There's no legal relief that you're claiming.
I'm
There's
holding
no
a judge in
motion before
contempt.
the court based in law or fact. So this court cannot address that last statement.
It's too early.
That sums it up nicely.
Your Honor, with all due respect, I would like a motion for finding the fact.
Denied.
Under what law and fact?
I made an oral ruling, sir. There's no requirement. I do so in writing.
Learn some law.
So you're denying a legal.
Oh, she's not messing
You're
with him today.
denying a motion for finding the fact.
Ma'am.
Yep. That's what she's
I know
doing.
what you're doing is legal, Your Honor.
All right,
don't
Mr.
have to
Brooks,
be
we're
sure.
going to
Lawful law.
move forward.
That's what we need to know.
At this time, I want to.
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr.
Go to law
Brooks,
school.
we're moving forward. So your
Doesn't
request
seem
is
like
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
it
advisements,
doesn't
and
seem
I'd
like
ask that you
I
stop
don't need
interrupting
your
me.
advice. I
No, I have to
need
give you
you-
advisements, sir, regarding
I
your right
need
to
you to do.
testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right
You know,
to
She's
testify.
gonna bounce into the
You
other
have a
room.
witness
We
to
have
don't
to
call,
need to
sir.
go
back
through
there.
anything with me on record.
Actually,
what's
I
gonna
do
happen.
so,
Actually,
sir.
you
That is
don't.
required by law.
Actually, you don't. You need to do your job as a public servant
Mr.
and
Brooks,
honor the oath that you
I
took.
need to go
Your
through
Honor.
these advisements, and if you're going to keep
You're
interrupting
gonna
me, I
forfeit
will,
your right
you
to
will forfeit
testify
your
if
right
you
to be
keep going,
present,
yes.
and you
So
will
you're
be
holding me in
removed
contempt
to
again.
the next courtroom so that I can properly go through these advisements
I
without being
still-
interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet
Then
again.
you're
Mr.
going
Brooks,
to
I've not
forfeit
held
your
you
right
in
to
contempt.
testify.
I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State
They
versus
might not.
Vaughn.
Oh, yeah.
It's also
We'll drag 'em
referenced in
out.
State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with
I
all
need
It's gonna be rough.
you
in
to
Illinois
not
versus
interrupt
Allen,
me.
in
This is
Illinois
another
versus-
interruption.
in Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying to
of
have a
Illinois
debate.
versus
I'm not
Allen.
trying
You
to have a
are,
debate.
you
I'm
are
merely trying
advised
to
that
understand
continued,
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that
I've
forfeiting
said that
my
multiple
right.
times.
You
I've
said-
given you multiple opportunities
You're
to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt.
Mr.
No,
Brooks,
she's not.
By
I'm not holding
removing
you
me
in
from the
contempt
courtroom.
for the second time here, and I've
Your
also
Honor,
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois
Illinois.
versus Allen. It is a clear indication to this
I'm
court
trying to
that
understand,
he
Your Honor.
wants to disrupt these proceedings, even
That's
in
not
a
true.
mild manner, tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
the standards of
because it
decorum and
doesn't-
civility, and
Illinois
Brady
versus
Bedrocks
Allen.
is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
Make
I
sure
think
the
the
court
death penalty
really
should be available.
From-
Once
As soon as you
cameras
say Illinois.
are there, again,
It
I'll make
doesn't
sure
state
that
that's
the
enhancement.
when he is there.
Cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay, so
courtroom. I'll
you're
be
making a
stepping off.
tacit agreement.
Attack it agreement. Oh
Agreement.
God, we start early.
Oh God.
We got a tacit agreement based on Illinois versus somebody. Oh, we start early. We start
made it.
early.
25 minutes for him to get thrown out of the court.
I think we need to do it, John.
The world frightens and confuses me. My primitive mind can't grasp these concepts.
Oh God.
Oh, good Lord.
You know, he did.
Where's Ben? I saw Ben came on briefly this morning, and he said like it's 6 o'clock in the morning out here. I got to take the dog out and take a shower.
Well, maybe he'll be back.
I wanted Ben on. Oh wait. I may have summoned him. There he is.
Speak of the devil, and he shows
There he is. You say his name and he shows up.
Like
Ben.
Beetlejuice. It's not even 7 o'clock here. You realize it's not even 7 o'clock here.
Oh, it's early, brother. It's early. I just wanted to use this particular break. I don't know if you saw yesterday, John. Ben's former client. Ben's former client, God love him, decides to call me from the Clark County Detention Center. We had a nice chat.
I haven't had a chance to watch it yet, so no too big spoilers.
Spoiler alert.
Don't worry, because we all decided that everyone decided Ben needs to take up the cause again. He needs to come back in and straighten the situation out.
You heard him. He knows more than me. He knows more than Joe and me combined.
I don't know. I did push back on that.
Measure up.
I don't know. Those I've seen. But by watching that case, I'm like, I've seen both of them in action. They seem pretty good to me.
We're no match for the beautiful mind of Kim Blandino, right? Yeah. I mean, I like the irony of him having to try and get private counsel in order to be able to represent himself. I just love that irony of what he was talking about yesterday. Well, I might have to go hire a private attorney who can argue for me to represent myself. It's delicious irony.
I'm not sure I'm volunteering for that assignment.
Oh, man. Oh, good times.
Yeah, I'm just thinking about like the Rain Man like montage where it's like, oh, God, he must honestly believe that he's some sort of freaking genius.
All right, for everybody, we're going to go back to it. They just took a pause in the trial. So the people who are not familiar with this Kim Blandino situation, don't worry about it. We're just taking the pause opportunity because there were happening situations there. That's
absolutely watch that interview. I'm going to have to during the break.
We had a nice chat. I'm looking at that. I don't know her, but like I feel comfortable with Judge Levitt at this point. I'm like, you need to sign your probation agreement. Go back. She's gonna violate you on the probation. She's gonna sentence you to time served, and she's gonna let you out. And then you behave yourself, and life goes on. I don't know. That's my guess. What do you think, Ben?
I can see that happening. I think she'll give him, 30 days, whatever, for the violation and reinstate him. I can see that.
She's not out to get him.
No, she never has been.
Right. So she'll be like, okay, fine. You did a little time because you got sloppy while on probation. You didn't sign it. You're fine. Time served. Now you can go.
And
you spend a little time over.
And an added condition, do not drive unless you have a valid driver's license. Something like that along those lines, I would imagine.
But he won't do it. He won't do it.
Well,
and then she's going to say, okay, well, then you're not on probation. I'm imposing the sentence. You already have the sentence. It's just not now we're
right.
Now it starts. Now it commences.
Don't need a driver's license in the who's gal.
Yeah. Yeah. I'd love to get Judge Manning on the panel. Dancing Blandino time. That's not a bad idea. You know what? Just in case you guys, here's a little background. Here's a little background for those of you who don't know what I'm talking about. This is what I'm talking about. All right, you get the flavor.
I feel like he's too old to be that stupid. Like, how did you make it through life?
I couldn't hear.
Sorry, I was saying, he seems too old to be that stupid. It's like, how did you make it that long through life?
It is amazing because he's not stupid, but he just misses big things, and then he will not amend them.
No, and
And you can't argue with him. He won't ever, you try and reason with him, he will only entertain his idea. He won't engage. You're not understanding him. Like, well,
and that's basically what
Anyway.
Brooks is doing too. It's this sort of like bullish, like, pig-headedness where you just can't get past their preconceived ideas
Madam
of
Clerk,
how
will you please
things
get
work.
verification that the audio working in the neighboring courtroom.
Ah,
All right, thank you. I do have verification.
I
There
called
are
it.
headphones on the table in front of Mr. Brooks, should he choose to wear them. I
So this
see
is gonna be a
he's
big
reading
narrative
from
mess.
The book at the moment. I do
He's
need to
going to
make a
complain that
record
he
that this
can't
morning,
hear.
although Mr.
He's gonna
Brooks
try
was
and
not
explain his
raising
right
his
to testify if
voice,
he
there
so
were
chooses, and
repeated
he's not going to understand it.
interruptions. He wanted to debate rulings that I made after the fact. Just this morning alone,
Somebody asked what's a colloquy. It's basically a fancy word for a conversation.
about 26, 27 different times he interrupted me or spoke over me. Once I made a decision on his motion to dismiss and his request to recall a witness, he then asked if I for written findings. I denied that. He then asked for what law I was following. I indicated I wouldn't explain that further, that I already made an oral ruling. He asked for a stay. He asked for dismissal. All of those things I either denied or said I wouldn't answer, specifically as it relates to the request for an interlocutory appeal, since I would not be the judge or court to which a request would be made. That is something that would be made to the Court of Appeals. And although I would have authority to grant a stay pending appeal, there is no appeal that's pending.
Although he doesn't know the difference, so whatever.
I gave Mr. Brooks multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and
Is he
would
hiding
be
behind a
taken to the
Bible?
Oh, look at
neighboring
this.
courtroom. I believe I gave that
Oh,
warning
dear.
at least twice.
Look at
Of
this.
course, this comes on the record before this court over the first 15 days of trial, where Mr. Brooks has, by his conduct,
I mean,
forfeited his right
that's
to be
comical.
Really
present on
hiding
a
behind a
number of
Bible.
Yeah.
occasions due to his conduct. I do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up to today, and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify
take the
himself,
wheel.
there's a very important colloquy I need to have and an advisement of his rights that I need to go through. And I simply am not able to do that with him constantly interrupting me and then not respecting the oral rulings that are made. Of course, at any point in time, Mr. Brooks can ask to be brought back over to this courtroom under Illinois versus Allen. Of course, he needs to pledge that he
That's what I'm
is
talking
willing
about.
to conduct himself
There.
consistently with the
Thank
decorum
you.
and respect inherent in the concepts of courts and judicial proceedings. I, of course, have repeatedly, even without him making such a pledge, brought him back into the courtroom where I felt a sufficient time has
The issue is
passed.
he doesn't have any witnesses.
And he,
Either
at
he
many times, has
testifies
been able
or
to
we're
confirm
done.
his
We go to
conduct.
closing arguments.
I would note during the vast majority of the testimony that was provided during the state's case, he was in the courtroom. If not during the entire time, he was able to cross-examine witnesses. We had a couple of issues during the testimony of witnesses he called. And of course, last Friday was, in my opinion, probably one of the most challenging days, I should say, to date. It's my hope that we can continue with Mr. Brooks in this courtroom. At some point today, I'll
Mike, that
certainly
picture of
invite him
him
back
hiding
over
behind the Bible needs to be the
when I
thumbnail.
get through these
It's perfect.
advisements. Mr. Brooks, you have been muted. I will make that put that on the record as well. I will unmute though and ask Mr. Brooks, because you did not answer the question previously. Other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse to call today? I need an answer to that question, sir.
He's like, I was just reading here. It says, thou shalt not kill. Could have used that information a year ago.
Are we addressing subject matter jurisdiction?
I'm going to mute him
Well, it
just
was
for
more
a second.
prominent,
No,
you know?
I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction.
It's talking
I
to
have
John
issued a
319.
written
John
decision
319,
on
everyone.
that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting
I'm
you.
from my Jeremy DeWitt says.
Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
Your witness list isn't in the Bible.
Jurisdictional challenge right here.
Pretty sure they're all dead.
So are you going to address subject matter jurisdiction and prove it for the record or not?
So I've
No.
asked Mr. Brooks
Okay, that'd be a no.
witnesses to call other than himself. He has declined to answer
It's
that
too early for
question.
the robe, but we're getting
Sir,
there.
if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity, you will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted. I'm not sure. I don't know when you muted.
Did he mute himself?
Well,
Yeah, I can't hear
me
him.
muting you doesn't affect you being able to hear the court, because
Yes, it does.
that only
Yes, it does.
mutes your
Yes, it
audio
does.
coming into this courtroom. I confirmed already
Why is my
that
audio muted to begin with?
that is simply a misstatement. I confirmed with the bailiffs that the audio and visual were
Why is
working.
my audio muted to begin with?
Because you interrupt the court repeatedly.
Because
So I'm
you
going to
don't know
ask
when to
you
shut up.
yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning, and specifically now?
No, mommy didn't show up.
I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning?
You're an embarrassment.
He's been unmuted though, for a while now. We can obviously hear him. I will ask Mr. Brooks a third time for the record. He's finally putting on the headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
God almighty. Oh,
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear it. I don't need to be muted.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false. I have
ain't saying
confirmed,
nothing about the audio
It
not
perfectly
working, so
can't-
you need to
Oh,
stop
he's gonna
lying
blow
on
up.
the
The judge
record.
is not.
I'm not lying on the record.
She is not
sir.
as
Why
patient
not?
today as she has
Right, he is
been.
getting, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to
Patience
want
has
to
been
answer
declining.
any of the
Bizarre.
questions this court has.
And I think
I
she's
asked
done.
him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses other than perhaps himself. I then specifically asked him about Dawn Woods because that is the person he indicated he wanted to add to his witness list last week. And I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other
About
than
5
perhaps
million.
himself. I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in
Either
this
any of us
case.
would be getting up to a year in
I
jail.
would direct Mr. Brooks to the case of State versus Anthony, although that squarely dealt with a person's right to call to be themselves a witness in their own case. They talk at length in that case about how rights, even constitutional rights, can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct. Although a criminal defendant does have a right to present a defense, doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom.
She was
Mr.
ready
Brooks
for
has
this.
Demonstrated this morning that he is
I
not
might do a
willing
lecture
to
on Illinois
answer
v. Allen
simple
tonight.
questions
I haven't
about
decided yet.
calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic. When considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has
So she's not coming?
forfeited his right to present further witnesses. I would like to go through a number of advisements
sorry, the
with
jury's not in the
Mr.
room right
Brooks regarding his right.
But I think what they're
to
thinking
testify.
is, what the hell is he doing
I
this
will
morning?
unmute him for that.
Oh, he's gonna go crazy.
I asked Mr. Brooks to put on his headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point.
I wanted to hear him object to when his mom called him Darrell Brooks.
He's unmuted.
I gave you that name.
Oops, that's not going to happen.
I've also been advised by
Interesting, his mom's
not
not
just the
there.
bailiffs who are over there who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear.
You could create an issue for sure. Freckle Joy.
Mr. Brooks, I would like to go through with you your right to
Mom's car
testify
wouldn't
and your
start.
right not to testify. We are at the stage in the proceedings where
That's
it is
funny.
important that this court conduct a colloquy with you. I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin, 20. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen a page turned. If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that? No response by Mr. Brooks. Sir, you also have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that?
I think his brain is
Once
exploding
again,
right
no
now.
response by Mr. Brooks.
Just
The decision to
Great
testify
jackass.
is for you and you alone to make. Did you hear me say that? There's no response by Mr. Brooks. It's my understanding that Mr. Brooks has the
Oh,
equivalent
you finally
of a
figured out
12th
what the
grade
Fifth Amendment
education,
is.
that he attended school either up to or through 12th grade and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently in custody, of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours or any drugs or any alcohol?
By definition, he'd be a
I'm
hostile
not
witness
receiving
to
a response
prosecution.
to that. I'm aware that he's able to read
Yeah.
and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understanding. He
done
can read,
today.
write, and understand the English language.
Am I unmuted?
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you
Oh,
gonna
dear God.
verify it on record?
So he did,
Prove it on-
oh,
He
sweet
is a one-trick
Jesus.
pony, isn't he?
whether he's had any drugs, alcohol, or medication within the last 24 hours. I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? Although he turned and said, what did you say? Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
I don't hear everything you saying. So if you can hear me, I don't hear everything you saying, and you know I don't hear everything you saying. So cut the crap.
Mr. Brooks has interrupted with very
Did you just say cut the crap?
disrespectful words
court?
at this moment. I believe that he is feigning his inability to hear and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio, are simply false.
So
Mr. Brooks, have you made?
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this courtroom.
You need to stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here. That's what I said. So I would appreciate it if you would make the record clear and correct.
Clearly, he heard me say that for him to make that distinguishing
Yeah,
statement.
I'm sitting right
So-
here. Don't you see me looking all up to the microphone?
Oh, she's heading up.
I don't have an issue hearing you at all, sir.
Can you hear me when I'm right here?
We hear you.
Unfortunately, we
Once
can hear
again,
you.
for the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision? Have you made a decision to testify in this case?
Have you made a decision to tell
I will ask you again, sir. Have you made a decision to testify in this case?
Subject matter jurisdiction. Have you made a decision to be impartial? To answer what your name is? To answer if you have a claim against me?
I'm going to mute him for the moment just because once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me about subject matter jurisdiction. He's making statements about this court that are disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them. I will unmute him and I will ask him for a third time with the understanding that if he fails to answer the question in the affirmative, I will interpret his failure to respond as a no and that he is not going to testify. So once again, I am unmuting him. Sir, have you made a decision on whether to testify in this case? There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted?
Yes, you have been. Sir, do you want to?
How long have I been unmuted?
Sir, do you want to testify in this
You
case?
was muting me when I had the headphones on just a minute ago. You just said you was muted. So when have I become unmuted? Or did you even mute me in the first place?
Mr. Brooks, I'm asking you one last time. Do
didn't
you
ask
want
me
to?
nothing because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want to
You can't answer
testify?
for me.
All right, I'm going
can't
to
answer for me.
answer. I'm going to
You
mute
can't
him
answer
again.
for me.
Again, it is very clear to this court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to willfully not answer this court. This court, as I indicated earlier, is tasked with the duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum. Again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple requirement that he answer questions is required, frankly, due to the defendant's prior conduct throughout this trial, his repeated defiance, his repeated outbursts, his repeated failure to follow simple rules of courtesy and decorum, his repeated interruptions of this court, and this court having to repeatedly remove him to the neighboring courtroom and making findings that he has forfeited his right to be present. Of course, this record is abundantly clear at this point that Mr. Brooks is not even in the main courtroom because this morning alone, he is yet to conform his conduct to the simple standards of courtesy and decorum that are required of all participants in these court proceedings: the court, the prosecutor, the defendant, the jurors, the public. Absent an adherence to these simple rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on balance, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake. To go through the colloquy with the court
Wow.
regarding his right to
I did not
testify.
expect that.
I am unmuting
Yeah.
him.
It makes
and
sense,
will
but I didn't
attempt to go
expect it.
through this procedure.
His case
once
is
again.
closed.
If he
That is strong
fails to
3D
answer
medicine.
these questions,
I don't know if folks
then he is
realize
forfeiting
taking away
his
someone's right to testify in their own
testify
defense
by
is
his
She has no
own
choice. None.
conduct.
No, I mean, clearly.
Yeah,
but-
you're
I would
right,
acknowledge
but-
that such a procedure is certainly
Wow.
not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to.
This is where you start waving at the
this
screen being saying,
determination.
hey, I didn't mean it.
Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Do you,
Oh, she's giving
are
him
you
another
aware
shot.
that you have
Why?
a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Mr. Brooks,
Oh, dear God.
do you understand?
Practicing law
you're
from the
aware that
bench?
you have a
Is that what it said?
constitutional right not to testify?
He said that she's practicing law
Are
from
you
the bench.
aware that you have a constitutional right not to testify?
I don't understand.
I don't think she's practicing surgery.
Why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify, and that if you choose to testify, that you would be subject to cross-examination by the state. Did you hear me say that?
I don't hear you say anything. I don't understand what you're asking. I don't
He is
understand.
willfully choosing
Oh,
not to
come
answer.
on.
Sir, you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect, you've been trying
Did
to
you hear me say that?
answer questions for, I didn't hear you.
Whoa,
answer.
in my
Then you have to answer. That's how that works.
Yeah, you got to answer it.
And I
Sir?
don't understand.
Stop talking and I'll ask it again. Sir,
Can you ask me to stop talking?
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do this one last time.
He's this close to just
Right,
doing
but
closing arguments.
Yeah.
Once again, Mr. Brooks is being disrespectful. He is blurting out information. He reverts back to subject matter jurisdiction. He accuses this court of not honoring its oath. He just accused me of practicing law without a license. Again, all attempts to deflect away. I'm gonna mute him once again.
This guy's
This
insane.
court has simply tried to no avail to get
Yeah,
Mr. Brooks
he
to
tried.
answer simple questions, confirming on the record that he has been advised that he has a
My trap
constitutional
door
right to
idea is
testify,
looking better and better.
and that he also has a constitutional right
Push
to
the button.
testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back again to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full of his tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to
I don't see
honor
it.
the rules of evidence.
I don't see
or
it.
the
I think
rules
that's why
of
she desperately
procedure.
doesn't want to.
He would not
revoke the
even
right for him
answer
to
simple
testify,
questions regarding
but
his
he's
right
making
to
it
testify
impossible.
and whether he heard that or not. And based upon pursuant to State versus Anthony,
Seems that way.
and looking at the balancing test that this court must consider,
Nate the lawyer, everybody. Sorry, you came in hot,
this
Nate.
court simply
Oh,
cannot
it's all right.
Hey,
allow
I'm loving
Mr.
this
Brooks
show,
to
though.
get on the witness stand
What's up? How's you
unfettered
guys doing?
without an acknowledgement that he will honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court. He has demonstrated repeatedly
Let's do it.
throughout this trial that when this court makes a ruling that he disagrees with, he tries to engage the court in an argument about the legal basis, even though I've provided the legal basis on the record, or in the case of subject matter jurisdiction, even when there's a written determination on the issue. When looking at State versus Anthony, this is a case where the Wisconsin Supreme Court was faced with a similar situation, although not as egregious as I would say here, because in State versus Anthony, that was not a case where the defendant was ever removed from the courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed from the courtroom. So not as egregious as a case, but this court has a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated he has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence and the rules of procedure. As State v. Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Those restrictions, again, fall primarily under the rules of evidence and the rules of procedure. The
Everyone
court
wondering, should we
in
make this
Anthony,
clear as humanly possible?
cited the court,
Away someone's right
the
to
U.S.
testify
Supreme
is
Court from
huge.
Arkansas versus Rock, wherein that court stated the right to present relevant testimony is not limitless and may in appropriate cases bow to accommodate other legitimate interests in the criminal trial process.
That would be my guess.
For example,
At this
numerous
stage.
procedural and evidentiary rules control the presentation of evidence and do not offend the defendant's right to testify. Throughout this trial, Mr. Brooks has repeatedly accused this court of violating his First Amendment rights of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that a defendant may forfeit his right to testify by his conduct. Whether a criminal defendant may forfeit his or her right to testify through conduct incompatible with the assertion of a right was reviewed by that court.
He
That
can't
court went
behave.
on to discuss waiver and forfeiture and ultimately went on to conclude the following. We now conclude that the right to testify may in appropriate cases be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. The balancing test that this court must go through are the interests, again, as I've already stated, for the rules of evidence, the rules of procedure, civility and decorum, and balancing all of that against Mr. Brooks's right to testify. This court is not making an arbitrary decision. The decision I make here today is, in my opinion, proportionate to the conduct demonstrated by Mr. Brooks throughout this trial, and specifically today, based upon his failure to even engage the court in a simple colloquy regarding his right to testify and his right not to testify. He was repeatedly warned that the failure to answer the questions would be taken as by this court really as no, meaning the specific question, have you made a decision? And as for all of those reasons that this court will make a finding, he has forfeited his right to testify.
Excellent. Hear, hear. No judge.
Wow.
That's a good ruling. and he's
With that, then there are no other witnesses to present for the defense
He
before I
won't rest
bring
either because he
the
won't say
jury
anything.
out. I'll ask the state if you intend to call any rebuttal witnesses.
We have
No, thank you, Your Honor.
Thank you.
Yeah, let's give it to the jury for the.
I would like
For the
Mr.
execution.
Yeah, we
Brooks to
got
be back
we going to
over
closing now.
so that
Yeah.
he is present in the courtroom when the court advises the jury that the defense is resting. I realize that will be over his objection. I'd ask that he honor that. Mr. Brooks, I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't
Not
challenge
a
that
chance.
directly in the presence
Oh,
of the
just-
jury,
now I
I will
can
bring you
hear.
back over
Again,
for that. Are you willing to make that pledge, sir?
Make what pledge? I'm not making no pledge.
Sir, you
You asked me a question, now I can't answer.
yeah, no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent.
no, I don't believe that.
How can you coerce me into my right to remain silent? So you're not gonna protect my constitutional rights? Because I didn't answer nothing that you was trying to ask me before when I had the headphones.
He does not require
You can't
your
make a
consent
decision
to
for me.
proceed with the case.
You can't do that.
I believe there's bail
Violating my
in the other room.
constitutional rights.
Sir, if you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
When I know, you can't tell me what I decided to do because I didn't decide.
Yeah, she can.
Yes, she can.
Actually, she's the judge.
behavior.
Mhm.
Are you willing
That's
to?
what she just. With all those words she just said was to say just.
I'm not coercing you, sir.
Well, you're making a decision for me based on something that I did not say myself.
Last
Nobody
Friday,
cares.
I specifically directed your
Then why don't you
attention
say
to
something
State
and have
versus
input?
Anthony. I discussed very briefly at the end of the day on Friday the case law that is relevant on this topic, including State versus Anthony, Rock versus Arkansas, and Chambers versus Mississippi, to specifically put you on notice.
Do you recall what was going on Friday?
Mr. Brooks, I'm going to mute him again. I'm not going to have a debate. I've made a finding. I've given him yet another opportunity. If he's willing to go through the colloquy with the court, he wants to challenge me instead and saying he doesn't consent. His lack of consent to this entire procedure is noted for the record, based on his inability to pledge to this court that he will honor that ruling and be respectful of the jury. I'm going to leave him in the other courtroom. The jury's going to be brought out, and he will remain muted, and I will simply advise them, as I have throughout this case, that he's appearing from another courtroom and that his appearance from the other courtroom should not in any way be held against him or influence their verdict in any way.
Forfeiting is
I will
closed.
tell them that there are no
Yeah, he's close to doing that.
further witnesses for the defense. And then I'll ask the state if there is any rebuttal, and then the jury will be excused for the day, because we will have I anticipate will be a very lengthy discussion on jury instructions.
Oh God.
Oh, good Lord.
Again, I will advise Mr. Brooks that if at any point in
I'll
time he
be
wants to
back.
come back over, he needs to advise the
So
bailiff.
does it go
that
Chambers
does need to be
and
accompanied
pass
by
those out?
a pledge that he will follow
I'll be back,
the
guys.
rules of civility and decorum, and
See
he
you
will not
later.
specifically challenge the court's rulings regarding closing off of his ability to call witnesses or testify on his behalf. All right, let's have the jury brought out.
God help it. Do we have to cover the jury instructions, Mike?
I don't know. I might just dabble in it to see if because it's going to be a circus though.
I know, but oh God.
Would you have a life to
I
live?
don't know if I'll survive it.
What happened to Nate? I was just going to make the intro. I don't know if you've met Nate yet, Ben.
No, I haven't met him yet.
Well, that's all right. You've been on a stream with him now. We'll figure it all out.
Yeah, Nate's
I
awesome.
don't know, is
He's,
he gonna
he's the first one that ever invited me on to anything. We did a objection bingo with the Depp case.
Yeah,
It was fun.
Nate's awesome.
Think he'll get a jury instruction on subject matter jurisdiction?
Oh God.
Oh, it says Nate will be back.
Yeah, he said he'd be back in a little bit.
Although you never know how this is going to go. This is the hot thing today. I mean, all the action just happened. Mom didn't show up, and he couldn't get through the colloquy, as he likes to call it, soliloquy. And she banged him. She had no choice. She had absolutely no choice. What are you going to do? What's the other option?
I don't know, but like people are asking, is there an appeal issue?
There's always an appeal issue.
It's obviously an appeal issue. I don't think that they'll grant it to him, but
Thank you, everyone.
that's why
Please
she
be
was so
seated.
reluctant to do it.
Ladies and gentlemen of the jury, at the moment, Mr. Brooks is appearing from another courtroom. This must not be held against him in any way and must
Everyone
not
holding it against
influence
him.
your verdict in any
Yeah, David, I
manner.
actually think that way too.
At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
No rebuttal, Your Honor.
All right, then with that, I
Wise.
will declare the evidentiary phase of this trial
You've made your
concluded.
case.
I'm going to excuse the jury for the remainder of the day so that the parties and I go through all of the jury instructions. And I anticipate bringing you in tomorrow morning. Instructions may very well take most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not, by tomorrow
Can you do all the
evening,
jury instructions with him on
sometime
mute?
Wednesday morning or early afternoon.
They're gonna have
With
to.
that, all rise for the jury then. Please turn your notebooks into the.
That way we might actually get
I'll
through with
back
it.
to you during deliberation.
Wow. Well, that was eventful, though.
Come on, man. There's never a dull moment here.
Thank you. Be seated. Before we begin, I will have Teresa print off what at least we do have for both parties. I'd like to take a short comfort break. I'll invite Mr. Brooks to come back over, and then we'll start with that jury instruction.
I
No,
would
he
not
makes
choose
my
Brooks
day
over
look
Brooks.
like the greatest
Yeah.
client ever lived.
The devil you know and the devil you don't know, right?
Wow. I mean, okay, so it's funny because I'm coming at this from a civil perspective. You
All right.
couldn't get anywhere near this stuff. It's all attorneys. If you're sitting there smacking around like you don't know what you're doing for like 30 seconds, the judge is like, okay, that happens. Trial's hard. If you start playing this game for like 3 minutes, you're just waiving all your stuff. But you don't have so many. But they're not putting you in prison for the rest of your life.
True.
It's a much lower threshold to make the judge insane because they just like, look, we're working out a civil deal. If you don't want to do it, you lose. That's the very
Right.
quick conclusion in civil court. I know it's different, but have you ever seen a judge just close a case for another side? I haven't.
No, I mean it's this is rare, obviously, that someone. I mean, I don't know what his goal or end game is.
I
or he
don't
just
see
doesn't
any
know.
other option. If not, then John and I were discussing this. Then you've got a heckler's veto on your own case.
Right.
Well, I won't participate in my own case, so I can't be convicted. Well, hell, that you can see where that would be a problem. It would sort of destroy the whole system overnight.
Yes. Yeah, I can see that.
I
But,
mean, literally, just intellectually, can you think of any other option she has?
ask him again nicely, but this time say please.
Ask him
I
the
don't know.
Yes, yeah, you could. I mean, I think she did more than enough, and I think you think so as well. But like, that is it. Like, you can keep asking. Literally, your only decision as a judge is the number of chances you give before you close it down. That's it.
Yeah, no, she has clearly had a different demeanor today. This judge, she was not having it. She was over it. And I mean, yeah, I mean, there's nothing she could have done. I mean, what address subject matter jurisdiction for him? Like,
I think she started off ticked off that he didn't bring any witnesses today at all. And so she's like, all right, then let's just get done with this.
Well, they didn't. I mean, the jury never even came out. This is
No.
all preliminary matters. But you gotta. I mean, she didn't know if Mom was going to show up or if he was going to testify. Judge didn't know. She was prepared for this eventuality because that's exactly the way he's acted. So, like, you have to prepare for the guy just won't cooperate on anything.
I mean, she had the case law ready to go, particularly on withdrawing his right to testify under Wisconsin law.
I mean, I don't know if she has a clerk, but if she has a law clerk, that person's been pounding away on all the justifications doing exactly what she did, because
I'm sure
it was one of the obvious possibilities as over the weekend.
Yeah,
I'm sure.
But no, I don't see what option she possibly had at that stage of the game. I just don't. I don't know. I mean, if he refuses to participate, you can't, as a defendant, just clog up the wheels of justice forever on your own behalf. It doesn't work that way.
Yeah,
and I come at it from a civil perspective too. But sorry, go ahead.
Well, I just think, I think maybe he just thinks this is an issue for appeal in his mind. If he doesn't answer and she makes, you can't make that decision for me, when clearly she can. I don't know. I mean, is that someone said don't accuse him of foresight? But
she made a 15-minute oral record before she made that decision. That seems kind of bulletproof to me.
Yeah.
Oh, I agree.
And the record is clear. And I mean, I hate to tell y'all, but the appellate court that would see this in Wisconsin is all watching Law Talk with Mike, so they're already going to be aware of the record. You know,
fair enough.
Of course, they can't look away.
I think the second it. By the way, can he even afford to order the transcript? That's going to cost a freaking fortune.
Yeah. But he could.
Nobody's taking his case.
He can probably. I mean, it depends on Wisconsin. You guys know better than me, but I'm guessing he can get appointed an appellate attorney.
I don't believe you're entitled to appellate counsel.
Well, you are in Nevada, thanks to the Blandino v. State decision of 1996.
Ah, all right. I don't know. I don't know Wisconsin, but there are plenty of states where you're not entitled to appellate counsel.
No, Kim Blandino fought that issue in the 90s after his conviction lost. The Nevada Supreme Court ruled there's not a statutory right to represent yourself on appeal, and you don't have a First Amendment right to represent yourself on appeal. So he has to have counsel for his appeal.
Interesting. What is it in Florida? I don't do criminal in Florida.
Well, I don't know what to do going forward here. Should I just keep going? And the only thing is, okay, so this is, I mean, we don't have to watch this closely, but because it's jury instructions, but there's gonna be some crazy stuff going on.
Oh, of course. I
mean, if someone just said it in the comments, I put it up. If it was most cases, I'd be like, okay, we're, whatever. I'll cut this off. I'll see y'all tomorrow for opening arguments. That ought to be interesting. But this is just when this thing's going to heat up. I mean, what is this dude going to do during jury?
I mean, because he's so outclassed here. I mean, he just doesn't understand any of these, what jury instructions are, what instructions are proper. But he has to be part of the process in this. In selecting the jury instructions, he has to have a say. So, that's why I would say watch. It's like slowing down for a car accident.
John.
Yes.
John does civil work, but he's telling me in a conversation. I think it was on stream, so I'm not telling tales out of school here. He's contemplating taking a job as a public defender.
Yeah, they're
one of the
hiring.
possibilities.
I think it might be interesting. Do something
Have
a
you
little bit
lost your mind? I want, John, I want you to just watch a sample of these jury instructions before you make that final determination.
Oh, I've watched civil jury instructions. Those are worse.
Yes, yeah, civil jury instructions are awful.
But
But
I'm curious, how would you go about crafting an instruction to the jury that they shouldn't hold the fact that because usually it would be that the defendant chooses not to testify. How would you craft a jury instruction to address that matter?
Yeah.
I have no idea. I'm racking my brain
it's
on
not
that.
the matter. I think that's a decision of law the jury doesn't need to come back on. I don't think it's an issue of fact, so I don't think they need an instruction.
Oh my
She's made a
goodness.
judicial
7:50.
determination out of their presence
have to go.
that they're not privy to. That's it.
I've got hearings I got to get to, so I will leave you now. It's
All
been
right.
a
Thanks for coming by, Ben.
All right. See you later.
He's got to
guys.
prep.
Bye,
He's got to prep
everybody.
for getting back in the Blandino case right now.
Yeah.
That's right.
That's a heater. I think it's up tomorrow.
I got my bankers boxes all stacked up.
You got it ready to go? All right, Ben. Thanks for coming by.
Oh God. Yeah, no, I was looking at Florida. We have Rule 3111, and yes, post-conviction proceedings, you do have a right to counsel in Florida. So,
Look, that's what always cracks me up. That's a big difference. They're both great approaches, but that's the big difference between me and you. Like doing this, like I'm like, let's have fun, whatever. Like that. Somebody, Ben said, "Oh yeah, you have right in Nevada." That bothers you, so you're like over there googling it up, looking for it. You're like, I don't practice criminal. Do you have right to appellate counsel in Florida? You have to know.
I like doing the research. Like that is actually one of the things that I genuinely enjoy. I like legal research.
Well, I like being an attorney, but I find just the law part bothersome.
Yeah, well, there's that. I mean, I've been saying to people since I've been doing the YouTube stuff, I actually prefer teaching law much more than I prefer practicing it. Because it's interesting to me.
Yeah, you get into it.
Yeah, I'm a law nerd.
Oh, thank you, Lenny.
You know what I don't like doing is I don't like doing discovery responses. That's a pain in the butt. I hate it. That's like my least favorite aspect of the entire process.
Oh, that's awful. Jury instructions, discover that paperwork. It's so intricate. It's necessary. All the stuff that you hate is totally necessary. I understand why it's there. That's the functional process that separates law from just mass rule, honestly.
True. I know it's absolutely necessary. I agree with it. It's all very important. However, God Almighty, I would love to just already be a partner and have some associate deal with the privilege logs.
Mm-hmm. That's the worst part. It's like dentistry. It's like if you have a toothache, it's like, yeah, I gotta go to the dentist and get that fixed because it needs to be done. Yeah, but it sucks. You're not disputing the validity of dentistry. No, it's quite important. It's painful.
I mean, the profession was started with medieval torture, so I might have some questions about the validity of dentistry. But
back in the trial by jury days.
But it also, I think, dentistry also has the highest rate of self-deletion of any profession.
All right, so here's what I'm gonna do with. Should I close this and start a new stream just for jury instructions and just have it be chill?
Did she say when she was coming back? Because I might need to run out and get something to eat. I haven't had anything today.
They're not back yet. All right. Here's what I think I'm going to do, just to preserve this, because this is like important. I don't know what I'll call it, but this is distinct. And then I'm just going to do a separate stream for jury instructions. It's going to be very chill.
All right, cool. I might be an hour or so behind. I got to run out and get some food.
Yeah. Don't worry about it. We'll just keep that going. All right. Thank you. All right.
Thanks, everyone.
All right. Bye. Although I'm going to wait for just a second because I don't know if they're going to come back here.
Oh God, if they do. All right, I'm gonna give it till 11 o'clock, and then I'm getting out of here for at least.
Here's the problem. Every time I've done this, we were out for like 8-9 hours, and then like I cut it off. I like, and then like, there's fireworks, everything explodes. And I'm like, ah.
I mean, you know that this is going to be a massive freaking fight. And unless she literally just mutes him and he waives his ability to participate in the jury instruction conference, it's going to go on all day.
You know what? I think I'll just do this morning and afternoon like I've been doing. I'll keep it consistent. I'll just let this run. There will be a lunch break. I mean, I don't even know if they'll show it though. They might not show it.
No, they will. They've got to. They've been covering it wall to wall the entire time, no?
They'll go all Star Chamber on us. You think she should appoint standby counsel at this point? No. It's too late.
He waived it.
He waived it, and she made a fantastic record saying that's fine. When he wanted the attorney to withdraw, that's fine, but we're not changing fields. We are now starting trial. I'll let him out, but then you proceed.
And think about how unfair it would be to whatever poor attorney got tossed onto it at this stage of the process. I would just refuse. I'd say, take me off of the standby list. I'm done.
Right.
I'd sooner return my Wisconsin law license than take this up at this stage.
I have no idea if they can discuss that or not.
I don't believe so. I think that 403 kind of argument would work on that one.
Yeah, I mean, the jury's not supposed to be watching it.
Yeah.
Other than that, you got a First Amendment right, and you can say things, And they might have internal things that can't be discussed, and that's another issue. But as a matter of law, I don't think they've got a big problem.
I don't know on that one. I would say as a matter of just overabundance of caution, given the way that this has all gone, I think that both the prosecution and the judge are trying to go out of their way to dispel any sense of prejudice toward this guy.
Okay, you guys are talking me into. You guys are right. I just couldn't figure out. But you know what? That's what we're gonna do. We've been going all morning stream, stop for lunch, then do a second stream all afternoon. I think I'll just keep doing it that way.
All right,
but I mean, take a break. They're not in. We'll just chill out together here. That was one hell of a morning, though. I mean, you have to get through. Is Mom going to testify? Is he going to testify? When are you going to close your case? Those are the issues you have to address as a court. He chose those issues all got addressed by his clear contempt of court and his inability to participate.
Yeah,
but it's still a big event that it happened that way.
I've never seen it before. I've never seen anything that crazy in terms of, I mean, it wasn't like a blow up or anything, but it was from a pure legal perspective, procedurally, that was wild. I've never seen anything like that.
Yeah. And I thought she handled it well. She just kept making a record of everything, for the record, right down to, I don't believe that he has any audio problems. I'm saying it right now.
Right.
Pointing out that he's responsive to questions that would imply that he could hear the audio, which she's right. But I mean, like she anticipated this as a very likely possibility. That's clear.
And I have to be honest, good for her, because I did not particularly anticipate him behaving in that sort of a way.
I thought he would take the stand at least just because he wants to hear himself talk and be the center of attention. Right. That was his last chance. He's going to jail for life in all likelihood. Never to see the light of day again. And it's really disgusting, and everybody doesn't like it or whatever. But this is his last chance to just say, "I am the center of attention." He could probably squeeze a whole day out of it if he wanted to. Or at least a half day.
Easily. I thought we were going into Tuesday. I'm shocked that we're already at jury instructions. But he forfeited his entire defense because he couldn't cooperate. He couldn't shut the hell up for 5 seconds, answer 5 yes or no questions, and then take the stand if he so chose. He just couldn't do it.
And everyone's asking, is it appealable issue? Well, the guy's going away for life. He'll appeal no matter what. People say that, can you appeal? Can you appeal because she had him in the other room? Of course. And if you didn't put him in the other room, they can appeal. They will appeal the facts that occur because those are the facts, and he has nothing else to do, and he's in jail the rest of his life. There's an appeal coming, regardless. There's no magical way to handle this trial where the defendant doesn't appeal.
Oh, and he's going to be filing habeas petitions every year for the rest of his life.
Mm-hmm.
We all know it.
Freckled Joy. Freckled Joy. There's one of your fellow gingers right there, Freddie John.
Thanks. Yeah, if you do jail transport, HIPAA, you're probably covered under HIPAA. I'm not. People don't.
You think he's shocked? Do you think?
Nah, I don't.
You think he's surprised? I mean, I can't see any other outcome.
I think Denise means literally.
Oh, I was with that too. I'm like, I don't know how to interpret this. It's a good question either way.
No, I don't think he's shocked. I think he knows. I think he's a moron, but I don't think he's actually a stupid human being. Like, I think he knew where this was going.
Yeah.
That is very possible.
That is very possible. Like stomping his foot, like, Mom, why won't you? Mom wouldn't help you.
Mom's got nothing to say to help.
Mom wouldn't help you, and she would take a lot of criticism and abuse for your actions effectively, and it wouldn't help.
I feel like
it's a
really tough one to cross, though, because she didn't do this.
She certainly did.
Probably would come across as fairly likable, I would imagine.
Yeah. Or just don't cross her at all. I would just
maybe
you probably just say fine. You say a mom came to support her child. We all get it. Next.
Yeah, that's a good point.
But the facts the facts of this case remain.
There's nothing.
That's probably how I would handle it. But I'm not.
The only question that I would ask is, was this car registered to you? No further questions, and then I'd be done. Because she's useful for that purpose.
Sure. Yeah. Something like that. That's very factual and unemotional. That just helps a little bit. Yeah, you do that. No one can get mad at you for it.
Yeah. But no, I would not have. I don't know. I mean, somebody's saying the mom needs to be safe for sentencing. I don't know how in any way. I don't know how anybody helps on sentencing at this stage of the game. I just don't.
Let me see here.
On the record, appearances are as they were before. The record should reflect that Mr. Brooks continues to appear from the other courtroom. I would like to make a record regarding the audio and visual from the other courtroom. I've asked that one of the bailiffs who was present during the last session, present in that courtroom, come to this courtroom. I'm going to put him under oath and have him testify about the audio. I also have information from Zach Tremaine.
Here's another problem he's got.
He too will take the witness stand, and I just want to make a full record.
Oh, so they are actually bringing more people.
Decibel reading regarding the audio as well. All right, we have Deputy Kibler. If you could take the witness stand, please.
She can just mute him and leave him in the other room now.
Oh, yeah.
He had to participate in his own case in chief.
Sir, could
he
you
doesn't
please
have to
raise your
do
right hand?
anything for
You
going
solemnly swear
forward.
that the testimony you're about to give shall be the truth, the whole truth.
Put
and
him
nothing
back
but
in his cell with a
the truth? Would you
monitor.
please have a seat?
This is a fantastic way, though, to shore up the
Please state
record
your
that
first
yes,
and
he
last
absolutely
names
could
for the
hear
record.
and just
First name
refuse
is
to
Nicholas,
participate.
last name is Kibler, first name Nicholas, last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy?
I am.
And have you been assigned to work this case?
I have.
And were you present in courtroom 20
No.
this morning
It's over.
with Mr. Brooks when he was removed from this courtroom to that courtroom?
I was.
And did you make any personal observations regarding the audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that room.
Did you have any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom into the neighboring courtroom.
I could.
All right, that's the only record I wanted to make. State, have any questions?
Just briefly, Deputy Kibler, the defendant asked many times if he was muted or unmuted. Do you remember that?
Yes.
Can you confirm that even on the occasions when his microphone was muted, the audio in the courtroom continued to work?
It was.
And at any time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. He is telling us he prefers right now to be in that courtroom. He did not want to come back in here.
All right, thank you. Those are all my questions, Your Honor.
Mr. Brooks, you are unmuted. Do you have any questions for this deputy?
No.
All right, thank you. You may step down. All right, then I'm going to have Zach Tremaine also take the witness stand. Do you have, I have it on my screen. Can you do a project it, please?
Can I just share it? If I share the clerk's screen?
Yes. All right. There is, first of all, sir, stand and raise your right hand. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? All right, thank you. Be seated. State your first and last name for the record, please.
Zachary Tremaine, Zachary. Tremaine is Tremaine.
All right, and what is your position with the clerk of court's office here in Waukesha?
I'm the IT coordinator for the Waukesha County Circuit Courts.
Were you in courtroom 20 this morning following Mr. Brooks being taken to that courtroom?
Only temporarily. I was there when the call started, and then we came back to do a measurement of the DVD later.
There's a document or a photograph that's displayed on the monitors throughout this courtroom. Can you tell me what we're looking at?
So my phone is in the photo, overlaid on top of what we call the X panel. It is our AV control panel. So you push buttons on it and actions happen in the courtroom, AV related. At that time of the photo, my phone is registering 67.3 decibels in that courtroom. And that was when the judge or the court was talking. And then the sound was coming over the speakers in the other courtroom.
And what, if anything, based on your training and experience, can you tell me 67 decibels means?
I have that
It's
up.
plenty loud. For comparison, I did a quick reading in the media pooling room, which is CG6 in our courthouse. The meter there was reading between 55 and 65. So it's louder than the audio feed going to the media right now.
All right, thank you. Any question from the state?
Sir, I'm looking at the photo, and Your Honor, for the record, this photo will be made a court exhibit?
Yes.
Okay. I'm looking at your phone screen, and it looks like in the upper right-hand corner, it appears the time is either 9:26 or 9:36 a.m.
On my phone, yes, I believe our AV processor, which is the other time of 9:23, I believe that just needs to be updated, but
Okay,
it is approximately 9:26 when the photo was taken.
those are my questions.
They put this together
Thank you,
fast.
Mr.
I'm sorry.
Oh, go ahead.
Yeah.
Do you happen to know what the decibels are in this room?
I don't. I'd have to pull the same thing up on my phone while people are talking.
They anticipated
Thank
this
you.
whole thing.
Good on them. I
Mr.
did
Brooks,
not.
any questions for this witness?
For the record, I don't consent to being called that name. Do you know anything about the hearing when someone has the hearing loss in any of their ears?
I do not.
So it'd be fair to say you don't know if I can hear everything good from this courtroom.
I can tell you what the readout of the room is. Beyond that, I don't know.
Well, I can't see what photo that everybody else is in there seeing that was supposed to be that exhibit. I have not viewed that, so I don't know what's being referred to when you refer to the picture.
I'll have to show you that in a
Well, you learn
different
something
way.
every
I
day.
don't have the Zoom up and running, which would have been the mechanism to allow for an exhibit to be displayed. I can start that and have that
You're
up momentarily.
Clearly
Fair
able
enough.
to communicate effectively right
So give me a
now.
moment.
I didn't know you could move the
For the
captions.
moment,
like
we'll
that.
print it in black and white.
I thought
so
you couldn't
have it
hear.
until I can get the Zoom up.
Oh, he knows he's sunk.
This puts me a lot in the mind of Trevor Summers, and I just thought he wanted that moment so bad that this surprises me.
You are in the meeting now.
Oh, good. We're in the meeting now.
I need to get the other courtroom in, so just one moment.
I love my chat. I probably shouldn't announce I was closing the stream because we really dropped off and we're back. Thanks everybody for hanging with us. That's really cool.
Oh yeah, your people are the best.
And teaching me how to move captions.
I had no idea that was a thing.
Well, I have to stop the
Like, can you move the captions? What the hell if I know?
Okay, hold on, please. Can you do that? Stop the call Polycom to Polycom, and then I'm going to call it in through the Zoom so I can share the screen with the exhibit, which will actually help when we do jury instructions. Yep.
Why? Get an intern to print it out and just hand it to him. Why are we going through this?
Except now
It's not going to make a
both
difference.
systems are out, so hold on. One more.
I'm guessing by the idea that it's after 5 o'clock, I have some ideas.
That sounds pretty good. I'd like to be in Vienna right now.
You are in the meeting now.
Oh,
Lovely.
good Lord.
All right, so the record should reflect that I've now changed the audio visual from the Polycom unit to the use of Zoom. I've called in both courtrooms and they can hear from over there. And then I'll do
Yeah, see, they had to
Need to get
do a
back
lot more
on
for him to be able to
to the
participate,
email.
question witnesses, all
give
that
me a
stuff.
second. I have to go from double screen to single
He doesn't need
screen.
that anymore.
The way I sign in, but that'll take me just a second, and then I'll share screen so the color exhibit can be viewed by the defendant.
Yeah, you see, the thing with the defendant is this. We know you can hear. We know you can hear.
And don't worry,
All right,
folks.
now
Once this is
the
over,
court is sharing
330 million people, there'll be
screen,
more stupids.
and the
We'll find him.
Images being displayed. You see it? Okay, thank you. Any questions regarding that then, sir?
My question was, pretty much already answered. You don't know if me myself can hear everything you do in the courtroom, correct?
I do not, correct.
No further questions.
Okay, thank you, sir. I'll stop sharing. Okay, thank you, Zach. You can step down. All right, I just wanted to put that on the record since
You can argue anything. It doesn't mean anyone's going to care.
that was an issue raised by Mr. Brooks previously. Now, I need to get a copy of the jury instructions. They were quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was provided with a
dear
written
God.
copy as well. Again, it's all the same 107 pages, and then my written copy is on its way.
I said the value, return the value document.
This is going to go until
That's
next
if I'm
week.
not muted.
You're not muted.
107 pages of jury instructions.
I also
Jesus.
would like to again ask for subject matter jurisdiction and improvement on the record.
Your request is
It
denied.
has yet to be verified. It has yet to be verified.
Your request is noted.
Your Honor,
It's denied without further hearing or consideration.
I was just told that,
He's really touching on my banners.
It's supposed to be closed. How come I haven't been able to present?
I think he's going to forfeit his right to be part of the jury instruction
Asked
conference.
numerous times on the record to be able to do. I've said I have numerous documents that needed to go into the record. Why have they not been permitted to be made evidence? I didn't rest my case, so I don't know why that's being told.
It was rested for you.
And I have yet to be able to offer my
I agree. You're not
exhibits to
right.
the record for evidence.
The court did.
How is that so, Your Honor?
So the court did declare the evidentiary phase of this trial closed. I specifically found that you forfeited your right to present any further evidence or testimony when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to
67
testify.
counts.
It's just the fun of court.
Specifically as it relates to your trial filing, sir, I would note that
Stuff is
all
complicated.
evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
They were not hearsay, Your Honor.
Great
I
answer.
did what you told me to do. You told me.
He doesn't know what
I
hearsay is.
represent myself pro per, that I had to write everything out and present it to the court.
So that's not what I said. You're misquoting me, but in any event, I'm
No, that's
denying
what
your
you said.
request. I
So
said,
you're saying that I have no right
All
to
right.
present evidence
I'm gonna
and
move.
to have exhibits as the state's been able to do.
Mr. Brooks,
Are
I'm
you
not
denying
going to
me
have a debate about this
Are you
now.
denying me-
I gotta
are you
mute him
denying me
once
your
again.
right?
So, Mr.
You
Brooks, I
can
have
testify
muted
if
you
could
because
behave yourself.
I
You
declared the
can't
evidentiary
Put in
phase of this trial
documents that are your own
closed.
words. That
You
is
forfeited
hearsay.
your right to present further evidence and testimony previously by refusing to answer the court's questions. I will specifically address the filings. Number one, it is not true that I advised him that any filing would become evidence. That is simply false. Number two, filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay. Mr. Brooks would have needed to testify regarding any statements that he, from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth any exception to the hearsay rule that would allow this court to admit his written filings. I believe without fail, they are all irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback regarding jury instructions. It's typically a back and forth. We'll go through them. And I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that. And then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Muted.
All right, you're unmuted now, but but you have to not interrupt.
No, you can't, I'm not trying to interrupt, but how can you deny me the chance to put on an adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed them, you filed everything that I gave to you.
All right, Mr. Brooks, I'm going to mute you because this is not relevant at this time.
It is.
He's raised tone of voice. He's very animated. He threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified. I closed I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction conference. It is his choice. But if he is going to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment. I'll unmute him again, but you are advised, sir, you need to be proper. You need to not interrupt, and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
You need to tell me why I can't present evidence. How can you deny me the fact? How can you deny me my right to present evidence?
All right, I'll unmute him once again because he wants to continue. And again, I understand he's upset. I understand that. But he has himself to blame for his conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions.
Okay, that'd be a no.
The draft.
Yes, Your Honor.
Thank you. Mr. Brooks, do you acknowledge receipt? I believe you did by acknowledging it previously, but do you acknowledge receipt of the draft of the final jury instructions?
I didn't acknowledge nothing, and I don't acknowledge anything now. I have not received anything.
I would ask the bailiff to pick up the documents from the floor and put them in front of him.
And I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to put on
shot cuffs.
How can you tell me when I just stated?
I'm going to read it once again because again I understand he's upset. If the bailiff could, well, he put him on top, he put him on the floor. That's his right. They're not in front of him,
Yes.
but it's by his own conduct that he's done that.
We're through the F around
The record
phase.
should reflect Mr.
And
Brooks is
moved on.
muted because he wants to continue to debate with this
Okay,
court
go.
about my prior rulings regarding
Oh,
his
Lord.
forfeiture by conduct of his right to present further evidence on his behalf. I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count 70.
I love that she's just not taking it anymore.
I changed, hold on. 76, the 76 count, just want to make, it says near Frame Park, so it is in there, but that was just one question I had. All right.
Hey, are you building a box for
So
it?
state have any requests as it relates to the jury instructions?
Yeah, I'm just going through each one. I'm on page 50 of 107.
A lot of documents
Everything's
you
looking
can't
great
read.
so far.
Okay. Fair enough, there's 107 pages. I certainly can give the parties some time to continue to read through them.
Yeah, that's what he's doing. He's
Yeah, I
hiding-
can see this happening. I can see that. That's one of the few things he's got left. Make a mess in the empty courtroom. I'm kind of waiting for it.
He's literally hiding behind his banker's boxes right now.
Good Lord.
He built a box for it on the table.
Yes. So they can't see him. Oh, yeah, that's cool. I'm actually glad I didn't pull away from this. It's just getting good.
Oh, God.
No, boo boo. I'm behind the banker's backs. Oh, Lord.
Mr. Brooks is requesting to go back to his cell at this
We're
point.
playing
I will
hide
deny
and
that
seek in
request.
court.
He can remain in the other courtroom.
He wants to go back to the cell? That's.
I
I'd
think
send
that
him
might be
back.
appropriate at this point.
But it does make very little difference. He's going to be sitting in one room or the other.
Oh, my God.
The moving it around. Actually, this is enjoyable. It's the recognition that it's over. We all
I think
needed
it
it.
is finally dawning on him that he's thoroughly screwed.
Yep. Yep, that sums it up, Dan. That's exactly where I'm at.
Okay, I did not expect it to be that funny, but I love it. Every time they flash to him, it's just great.
Yeah, that's you said in the chat. It's like for most trials, I'd say cut out. But good point. This is what you're going to have in jury instructions in this
I know
trial.
he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. I can't decipher what he's
He
yelling.
appears to be yelling at the top of his lungs. Oh, God. I love it.
Oh, come on, unmute him for just a second. I want to hear. Yeah, just a snippet.
Yeah, just for a second. It would be fun. We can put it on the record.
Pretend like you're just checking on him. Whining like a baby.
He's yelling at the bailiff. That's the guy who's off to the left of the screen. Yeah, his left.
Oh, could we get a tase? Could we get a tase? Could he maybe he'll attack the bailiff and they hit the button on
Advise
himself.
Mr. Brooks, without a specific waiver of his right to be present, even if it's from the remote courtroom, he's going to remain in that courtroom. And that would require him to have a colloquy with me.
Yeah, we don't need any more colloquies. Seriously, just leave them in there. Some poor bailiff's going to have to be yelled at all day, but other than that,
I think he can deal with it.
it's not much different than their usual duty.
I have
Okay,
to say,
so this-
go ahead.
So we're looking at closing arguments tomorrow.
Yep.
The state gets to go first and last.
And he might not get to go at all. We might have a verdict tomorrow.
She'll give him the chance.
Yeah, he's going to blow it.
I mean, he did put witnesses on, and she's saying you're closed case because you've waived all this stuff. But there's enough that he can say, I should be able to argue from it. And she'll give him the opportunity, but he'll do this. He'll hide behind the boxes, and she'll say, all right, fine, you waived your closing argument. Not that it matters, because it would have sucked. Maybe.
Nah.
Oh, good Lord. Is he eating in there? I wouldn't doubt it.
Sitting there eating the jury instructions piece by piece.
Right. As if they're in sort of like ripping up the order, as if there aren't other copies or that particular piece of paper matters, you know?
Hey, UCC, original documents, man. Oh, Lord.
Mr. Brooks, I know you are still muted by me, but I know the audio is working, but I would ask you to specifically advise if there are any specific jury instructions that you are asking be read to the jury.
Oh, good Lord. He's gone into witness protection. Yes. Jerry, it's coming. It's coming. Yes, I do. I just hope we get the video of it and the bailiff isn't hurt. I also hope we get to see them activate the stun cuffs. Okay.
Okay, that'd be a no.
I'm going to use that clip up today.
Mr. Brooks, if you have specific instructions or categories of instructions that you believe this court should consider, I need you to write them down on a piece of paper.
We all know he doesn't.
I believe I see a writing utensil. I'm not sure if I see a pad of paper. We'll make sure you have that. But given your current demeanor, which is still seems quite animated and a loud raised voice, I'd ask that you write it down.
That is a reasonable next move right there, Joe. Thank you. He is definitely president of the He-Man Woman Haters Club currently. Oh, Lord. Well, let's get hot hiding behind this box. I better take my coat off. He is king of Fort Kick-Ass. He is. Well, we'll concede that.
I think he's declared sovereignty over Fort Brookville. Oh, Lord.
Happy birthday, Kevin. Hope you have a good one. That's awesome. Thank you.
God, I genuinely would love to know what he's screaming right now.
Thanks for telling me, Kathy, and thank you all for being here. This is hilarious. Don't get me wrong, but it's slow going in here. John and I have just lost our minds and are basically giggling at this point.
What else can you do?
We've earned that over the past few days.
That would be perfect.
Or kick me or big dummy. Yeah, there's so many good options. So many good options here. Mom did not show up to court today. He wouldn't testify. Judge closed the case. Said he waived his right to testify and closed the case on behalf of the defense because he wouldn't participate with anything, and she had absolutely no choice. There's my quick recap.
Well done.
Oh, good Lord. It's not beyond the realm of possibility at this point.
Oh, God.
Yes. He farts in our general direction.
Do we know the phone number for the court? I'm going to tell the IT guy to change the camera angle just to screw with him.
And who can blame her? Oh.
I have some not so safe for work comments on that one.
This is oddly cathartic today.
I mean, after all of the crap we went through last week, watching him have the meltdown instead of us, I'm kind of cool with that.
Yeah.
Only in Texas.
Texas is specifically included that in the statute. Is he still running his mouth?
Yeah.
I just want to make a continuing record that Mr. Brooks is I can still hear him even though he's muted.
I was just going to ask that. She can hear him through the wall.
His tone of voice and volume.
Oh, she can hear it from the other courtroom?
From the neighboring courtroom.
Oh my
God. I've never seen a trial like this. No, nothing like this.
I thought the Edgecombe trial was nuts. This is beyond that.
The upside is since he doesn't participate, it should be quicker because he's going to work it out with the state, which he doesn't know anything about jury instructions. He doesn't have any input into this.
And I'm sure the state probably drafted most of them anyway.
But they just put them in numerical order.
Or they're just standard instructions.
Yeah, they'll have pattern jury instructions. They'll use that for 95% of it, and then there'll be some weird circumstances where they draft something. That's the way it always goes.
Well,
I don't know how they do it in Illinois, but we had the judges would always have a box of like index cards in front of them, and they would just pull out specific cards, line them up, and be like, "You good with these?" And everyone would be like, "Yeah."
You know. Although, Trevor Summers participated more
Which
than I thought, and in a fairly rational way for him. I mean, it was still pro se, but he actually said some things that
but it
made
wasn't
sense.
insane.
Right.
Yeah, like I said, it was sadistic, but it was at least there was a degree of rationality. It's not like this.
So I'll advise you once again, if there are any specific requests for either instructions or categories instructions that you want this court to consider, please write a note to pass to the bailiffs who can let me know.
Oh, Judge, you're presuming he can write. Poor summer child. Me? I'm a New Yorker that happens to live in Florida.
You're Florida man now.
Apparently. I don't know what there is to learn from this, honestly.
Yeah, acting like the only lesson here is acting like a complete fool will lose you a case.
Yeah.
Okay.
I mean, all of last week I was trying to find something that made sense, and I failed dismally.
Yeah. He didn't get a theme for today. The rush to judgment was rich. It's totally inapplicable.
Watch his gesture. He's still screaming at the freaking bailiff.
But she's just going through and straightening them out.
Yeah, I think she's literally just reading through them.
Yeah, I think denied is the word of the day, and it's a beautiful word in this circumstance.
Wait, you're saying that building a box fort is not appropriate? That could be a lot of fun. That's called trial prep. I like that.
Well played. That's some thinking there. That's some thinking.
That's awesome. I like that.
Yep. Well, yeah. It's hilarious.
It's the only way to actually get anything done.
You saw it. I'm just kind of sitting here waiting to see what's developing, and I heard your laugh, and I'm looking like, oh my God, he's making a box fort. This is happening for real. Oh
God. Oh, Lord. Yeah, I see what you did there, Apple. God, I would also give anything to see what he writes down as his objection to the jury instructions. That he didn't read, by the way, because he threw them immediately in the waste paper bin.
No, I'm holding off from the white. I'm going to try to get through the day. You know what actually happened? I mean, we have a moment. I couldn't get myself to go out this weekend because I drank all week in the afternoons watching this freaking trial. And I'm like, literally, I'm not even trying. Just like I can't do it. I can't go out.
Thank you.
I took it easy this weekend too.
I
What a
went
bad
full
thing.
spa weekend to recover
I
from
know
this
from
freaking
my
trial.
review, I noted a few spots that either in the headings have some information or words that might need to be removed. But why don't you go through and tell me what requests you have starting, and then we'll go page by page and just tell me what page number and what section.
So I think the first concern I have is with regards to the bail jumping. I know that we had charged, there's 2 separate felony cases. The defendant was out on bail. And I do believe it would be assistive to the jury to have the specific case number. So when we first talking about 61 of 107, we start talking about the bail jumping, and then we go specifically on page 63 of 107, and when we talk about count 74 and 75, I think it might be helpful to put the Milwaukee case number, because they are different case numbers, so that they know exactly what they're finding, that he was out on bail, and that as
Welcome to Law Talk with John, folks.
And those bail bonds were entered into evidence.
Never, literally never. My office, sure.
Let me look at the
On the actual court desk, no.
information.
And then just because I think this was just well, I guess I'll have you, when we look at the verdict forms on page 102 to 107 for the bail jumpings, there's verdicts for the bail jumpings for 3 separate counts, 74, 75, 76. I don't think there should not be one for 76. I believe that should be the battery.
That would be true.
Depends on your jurisdiction.
In all seriousness, I do have a video involving a pillow fort in court. It actually happened.
Did that actually?
Yeah.
I've never heard that one. If you have,
I called it Linus Goes to Court.
If you have a site on that, send it to me. I have to read that.
I don't know if I could find it, but it's in there.
I'll find it. I'll find it.
It happened accidentally.
Oh Lord.
It might.
My computer's just
Honor the box sport.
I'm going to search. I want to see what the information says. And then I'll ask Mr. Brooks if he has a position on that. Sometimes it's easier if we just list out, I guess, what the changes are requested. I'm going to make some notes and then we'll go through
They
them
released
one
the
by one.
jury already. So
And I don't believe it
everything is
was
just gonna be there.
spelled out in the amended information.
Say that again?
I don't believe it was spelled out in the amended information.
Right.
So that would be page 63 of 107, whether or not we want to put the specific case numbers.
I can tell you right now, I typically like to follow the information, so I'm probably not inclined to do that, and we can argue that though to the jury, but let's go through the list and then we'll get the defendant's
She can,
response.
she won't. She just wants to get done with today.
But we'll go through the whole list. So that's the bail
You
jumping.
probably order the boxes removed, but there's no need to.
With the verdict forms with regards to the bail jumping.
Everyone's happy. We don't want to look at them
Just
either.
Record, page 102 of
I need
107.
to see his face.
I believe there's a count 76, which details it as a bail jumping. I believe that should be the battery.
Thank you. That is awesome.
I did notice.
I can't believe you have 7,000 people watching a jury instruction
Yeah,
conference.
basically watching you and I have a catharsis and giggle. Jackass finally got there.
The motive
Oh, it's good.
instruction was incorporated on page 5 of 107. And I
Thank
know
you
that
all.
intent
It's fun.
is an element of the battery. I don't believe that was incorporated. I mean, usually it's a standalone instruction. I think the court incorporated it with the first degree intentional homicide because
I mean, if
certainly
they're
that
at
was-
105 of 107, they might
I
not
think
do an
that's part of the
afternoon
pattern of
today.
instruction.
Oh, it is. Okay, then we would ask for motive. I think that there's a 175 instruction that could be given as a standalone.
We needed it.
Oh yeah.
I'll look
And
at that.
brace yourselves, because the state's close is going to be brutal.
And then
We'll
on
do it,
page
but it's gonna be brutal.
65 of 107,
Yeah, but we're not going to get it today. That's what I'm
which
saying.
is
We're not
They
gonna
might-
get it today.
70, the preliminary instruction, defendant proceeding pro se.
But tomorrow's going to be
There's the
rough.
standard paragraph, which
Tomorrow's
is the
gonna
first
be
paragraph
interesting.
listed under this instruction, and then there's an additional paragraph.
Must have cried.
We are going to object to that additional paragraph. I think it highlights the defendant's bad behavior. So I'd ask that that be taken out.
I'm not going to make a prediction on that one.
Wouldn't surprise me. I sure didn't. I did not see that coming. I'll tell you that, Bill.
All right, I made it.
But I love it.
Keep going.
And thank
Okay,
you.
With regard to page 106 of 107. I believe that those were add-ons at the end that the court wanted to question the parties about.
Yes.
I believe that there was 325 should be given. One of the witnesses for the state did testify. He did have one prior conviction. I believe a witness for the defendant testified that he had a number of convictions.
It's
With regard to
complicated.
that same page, 106
Yeah.
and 107,
Yeah.
instruction 141, where identification of
Usually
defendant is
each
the
charge
issue.
will have maybe two or three different
I
instructions.
don't
that
know
are
if it is an
relevant.
issue.
and
That
you have to
wasn't
give them
raised during
all
the defendant's closing
sequentially.
arguments. His opening arguments. I would know that, or note that the defendant would sometimes cross-examine people on if they were able to see the person driving or the description of the person driving, and he would cross-examine them as to their ability to perceive that. So I guess that would really be up to the defendant if he wishes that to be given. On page 107 of 107, instruction 172, circumstantial evidence, flight, escape, concealment, the state that was included in the initial instruction that we requested, and I would continue to request that instruction be included.
It's really just flight, though.
Correct.
What's that number again?
172.
I know, it's just not there. I saw it, it's fine. But only as to flight. I made a correction on it to find it.
Oh God, nobody's allowed to bring up international shoe ever
And I
again.
would say
Yeah,
concealment
sure.
to some extent, because he took off some clothes that would have identified him. But again, his running away, his trying to conceal his identity by removing some clothing that was identified by numerous witnesses as him wearing a hoodie or a light colored.
Just so everyone knows, if you ask me to do coverage of international shoe, the answer is going to be no. Go take Civ Pro.
When someone's dropping international shoe on you,
Those are all.
you know they
Do
did
you
their
have
time
any
at a law school somewhere.
requests as it relates to
Yeah.
instructions that are not in the packet that should be?
No, Your Honor.
Right, let me turn to Mr. Brooks just to get whether he has
It's a
any
case about minimum
business.
context.
I'm not asking for.
Right,
a
It's
response
a
yet, Mr.
jurisdiction
Brooks.
issue.
What I'm asking you for is whether you have any requests.
It's
jury
one of those cases
instructions,
that everybody in law school always
or
has
in
to
your
cover, and
review,
it
you
is
think
dry as
anything
hell.
needs to be changed, deleted, added, etc. I know I'd ask that it be put in writing, but I'll also give you this opportunity to verbally advise the court and make your requests. Do you have any
No,
requests
don't do
as it
that.
relates to the jury instructions, sir?
Bad idea.
I would note he put two boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off, so I can see the outline of his arms.
Craig said she just could make a record of all of
Back
it.
of his chair.
We do a GoFundMe to get a copy of this record.
Unmuted.
We could do dramatic
confirmed
readings of
previously
it,
regarding
like
the
Nick
audio
does the
working,
unbutted
and I will
stuff.
just ask him a second time, sir, do you have any requests
She knows damn well he's not
as
going to answer.
relates to the draft
All
packet of
records.
jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so
Yes,
we
I
can
think
see?
that's fair. I'm going to advise the bailiff to remove the box so I can see
Thank you.
Mr. Brooks.
Oh,
I don't know what he's doing behind there.
They're
I
destroying
like the box
sport.
but this will be fun. This will be fun. I
You
want
have
to see the
quieted
look on
down.
his
He
face
hasn't
behind the
heard in a
boxes.
while.
Is he like,
Maybe there's a chance he's in tears.
If you could move the second one because it can interfere with the microphone as well.
no, he's just going to duck beneath the monitor. They can't move it.
Where's his Bible? He could hide behind that.
Yeah.
Mr. Brooks, I'm going to ask you for a
Oh, your
third
poor
time.
box
Do you have
for
any
it.
requests as it relates to the jury instructions? Any
where are my
requests
boxes?
for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
He has no idea what's going on right now. Just so everyone's
Because I couldn't see you, sir. I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey man, you don't gotta talk to me like that.
Do you have any requests
First of all,
related
what?
to the jury instructions, sir?
Man, yeah, I got requests. It ain't like they gonna be honored though.
As it relates to the jury instructions, sir, what are your?
I heard what the hell you said, man.
Woo-hoo.
Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks, do you have any
I'm
requests?
tired of my rights being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
All right, I'm glad we stuck through this.
Yeah.
What you think I said when I didn't get consent for you to do any such thing?
This is much more exciting. than
I
what
understand
jury
you may be upset, and I really do,
No, you
but
don't
I've made my
understand nothing.
determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't.
I'm gonna mute him again because he's not answering the questions that I'm
No,
very
let him go. Come
clearly
on.
asking him, and I've given him
We need
5
content.
opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that
We'll try
answer.
the next time at
I
TSA.
can hear everything you're saying.
Mr. Brooks,
Do you think he punches the monitor at some
I know
point?
the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you said.
Then you should put the
What about
headphones
that
on.
Don't you understand? What about that? Don't you understand? If you see headphones, you can see everything.
That you're lying. That's what we don't understand.
Have you asked for headphones to be provided, sir?
I should have to ask for them. I asked for my boxes to be moved.
I believe they took them away previously because you were so agitated. They were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop. You sit up here and do everything you do.
Yeah, to some degree.
You think you gonna, you think
If he does, it would be a cautionary tale.
Right.
you ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury
Yeah,
instructions?
I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah, I
it?
got the headphones on. You can't see that?
What are your requests as it
Can't see that?
relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image called sir. Now it's all this sir and all this. I'm gonna get where I'm going.
Let's get Netflix on this.
Trying to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
I need to know what your position is regarding the jury instructions. And I need
Stop
to know it
asking
now.
him. He's forfeited the right.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
It's not double jeopardy. Your objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with? You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb twice. I'm already charged with the same count in Milwaukee. For the same
Those are 2 different incidents, dummy.
So how am I charged with that here?
If I shoot
I'm
2
not going to
people, I
provide
get charged
a
with
legal
murder twice. It's not
explanation
double
other than
jeopardy.
to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
Yeah, I'd like to be in a locked room with him for.
I understand your position. I'm saying it's overruled.
You always want respect, but don't want to give it. I'm charged with the same.
Nothing was double jeopardy in this case.
I've already been charged with. That is double jeopardy. You can't charge me for the same exact bail jumping that I'm already.
And by the way, he's focused on the bail jumping charge as opposed to, the 6 murders.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Okay.
That's the distinction.
Thank you, Your Honor.
Clarify it for you?
Just so we can make it clear.
It's the same offense. It doesn't mean it's the same factual basis, sir.
He is not charged with bail jumping with the date of violation of November 21, 21.
Oh, God almighty.
In Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
Yeah, he's melting down because he realizes he's at the end of
sir.
his rope.
What other requests do you have as it relates to the jury instructions?
And he probably had all weekend to figure that out.
You can't charge me in pursuant to a case in Milwaukee.
What's up, Ben?
Hey, how's it going?
Charged with bail jumping for that already.
What'd I miss?
Absolutely.
You can essentially say, oh, well.
Honestly, the least boring jury instruction
It's a different date of violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond.
Oh, you saw me back here. I was like, I'm back here, I'm back here. I'm like taping it in the chat. Help me, I'm trapped in the back.
Oh, we got a hissy fit. Come on.
Oh, man.
My understanding, sir, is there's different dates of
Y'all missed the
violations
box
as it
fort.
relates to
The
that.
box
So I
fort.
noted your objection now repeatedly. I understand it. Your request to, I guess, dismiss the bail jumping counts are denied.
Refuse to cooperate.
The court waived it for him.
Mm-hmm.
Whether it's one count or both, it's denied.
Am I not being understood? You can't charge me with the same charge twice. You can't.
It's two separate cases, sir. There's two.
Oh,
Is
man.
it that 971.23? Is it that the statute? that refers to the double.
All right, sir, I'm not going to have an argument. This isn't fruitful. I understand what you're saying. You're saying there shouldn't be 2 counts of bail jumping. You believe it's double jeopardy. I disagree with that. They're separate.
I'm already charged with it though.
This is a circular argument, sir. It doesn't change the
All of
fact
his
that,
arguments
from
are
my
circular.
perspective, the 2 bail jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the jury being instructed.
Wow.
What other requests do you have, sir?
Talk over me. Don't talk over me. Just like you don't
She's
want
the
me to talk
judge,
over you.
idiot.
Just like you don't want me to talk over you. Just like you don't want me
Mr.
to
Brooks,
disrespect
what
you.
other
Because
requests
everything I
do
say-
you have?
And I just asked you not to talk over me.
Oh gosh.
He's hiding on purpose.
You've been making your record
Yeah.
all the time you've been over there.
That's the box for it. He basically took his banker's boxes and built a wall in front of his face.
Oh,
so you
it's
could see
delicious.
him on the camera.
I almost cut out. I'm glad we're still here.
Like nothing to go over here. I'll let you do what you was doing.
Oh, he let her do it. Okay.
He's letting her do what she's doing.
How gracious of him.
He's such a nice guy.
Well, of course he's the one in
We
charge.
both know that what you're doing is not right.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand
You
that.
can't refocus my attention.
Yeah,
If you can't
refocus
answer
this
my
guy.
question, I'm going to move on.
Refocusing is not something that he's good at.
Refocusing
I'm
is
going
allowed
to
him
mute
to
him
talk
once
more.
again. He refuses to answer simple questions regarding if he has any requests. He just made an argument regarding the bail jumping, so clearly he has an understanding about the law as it relates to that. It may be a misunderstanding about the law and double jeopardy. He made an argument. I've denied
Hi,
it.
Christina.
I'd like to know if he has any other requests. If he can stay on topic, I'll I will unmute him again, and he can tell me the list, just like the state went through a list. I need to get through their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here is your opportunity to give me your other requests.
He
Not
can't.
debate
He
with me.
threw out
no prayer
the
ruling.
instructions.
Go
There we
ahead,
go.
Mr.
Who
Brooks.
gave it to them?
Don't sit up here and try to play no game talking about you giving somebody an opportunity that you haven't gave me an opportunity to properly defend myself and put evidence, put stuff into evidence, which I've asked you repeatedly to do before we even got to the trial. You told me you wasn't in the evidentiary phase.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, it's not. No, it's not. So please stop being incorrect, Norman. Please.
Well, apparently he can't count either.
Do you have any additional requests as it relates to the jury instructions?
Yeah.
Oh.
That first count 74 bill jumping needs to be dismissed. You can't charge me with 2 things. You can't charge me with the same charge twice.
All right,
Oh,
I made
God.
a note of that. What's the next issue?
Either one county gonna charge me with it or y'all, but it can't be both. It's the same, it's pursuant to the same exact thing that I was on bill for. The same exact thing. The same exact
They shouldn't have
thing.
sent the jury home. They could have done closing arguments this afternoon.
On 2 cases from another county.
I've made a note of that. What other requests do you have?
Now's a good time to address subject matter jurisdiction.
I'm not even able to adequately.
It's always a good time to address subject matter jurisdiction.
Is there ever a bad time?
But it's a vapid argument because it's a criminal trial in state court. This is if they don't have subject matter jurisdiction, who has it?
Mr.
I know
Brooks,
that. You know that. Ben knows that. Mike knows that.
I've made a
There's
note of
one
your
dummy in the
request
world
as
that
to
doesn't
count
know that right
74.
now.
Do you have any other
Like,
requests?
no
He just heard that phrase
Instructions.
and he's just latched on to that
Yeah.
like
Subject matter jurisdiction.
Why do I have to even sit here in this courtroom at this point?
It's a state court criminal trial.
You've been doing
Did you
what I
commit
like
the
to do.
crime within the jurisdiction
state.
of the state? We're done.
There's your
Your objection
subject
for
matter
lack of
jurisdiction.
consent is noted for the record.
Okay, yeah.
Any other requests,
You
sir?
talking big game. You talking big game to save yourself another face. But everything got put together and has no merit in your court. None.
All right, I've asked him many, many, many times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests as it relates to the jury instructions?
It would have been fun.
All right, he did not answer. So I'm muting him again.
She can't move on because
he has made as it relates to the jury instructions as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense. But
I love that she has no
was
patience
made
today.
based on his conduct and his conduct alone, as I've outlined already on the record. So the only request that he made was as it relates to the bail jumping counts. I'm denying those
He's still going.
requests, whether it be to dismiss one count or to dismiss both on double
Still
jeopardy,
yammering.
or to just not instruct the jury. However way I interpret it, I'm denying that. All right, let me go through the state's.
Your Honor, can I add one more?
Sure.
I'm sorry. 154 summary of evidence. I believe we had a map, actually two maps that summarize the, we had three maps. I think the one was summarized his route, the path that he took. The other one summarized the victims who were struck in the specific locations. And the other one summarized the positions of the law enforcement officers at the various intersections and throughout the parade routes.
I'll make a note of that.
I'm
We
doing
also
great, Maria. How are you?
instruction either. I mean, that was given to them at the time.
He's
I
trying
don't
to
know
make
that
this
it
absolutely
was
100%
read, but I think we need to consider that
appeal
as
proof.
well. That was my version of 152. All right, so let me go through
Is the fort coming back?
list
Oh, he's doing it
from
again.
the state.
He's building the fort again. Fort Brooks is coming back.
Oh, sweet Jesus. What?
Return to Fort Brooks.
So I
Brooks,
consider
do
the
like the
request
Google.
by the
Let's go.
state.
Is that one going to go on top? Is he going to do the three boxes?
Information they put in.
Can we get him a
the-
blanket or a sheet or something to?
Is he going to do three boxes?
To include the specific case numbers. There's evidence, of course, that was received regarding the two separate cases out of Milwaukee County that form the basis for
What is
both
he
of the
doing?
bail jumping counts. It will be up to the jury
I
to
told you.
review the evidence and make a determination as to the verdict forms, though that were referenced previously, at least the description of them in the
This
jury
guy is
instruction
sick.
that obviously the third count of bail jumping is incorrect. That needs to be battery, and that
Build
changes.
a wall.
I'm also
Build
having
a
them
wall.
include all of the numbers for the jury instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case, I want to be very clear with all of the numbers. So I think I've addressed the first two bullet points. As far as the motive
I will continue
instruction
to
as a
rebel.
standalone, I believe that is appropriate. And I'll instruct Madam Clerk to include that.
Mike, I'm so glad you did not decide to cut the stream.
As far as where it goes, I'm gonna just, any instructions that we add.
Who said?
Well, this is the best.
Who said jury instructions were
conference I've
dry
ever
and
seen.
boring?
must be- Unless there's a other request that's made. Then the state also made a request as it relates to jury instruction 70,
Indeed.
which is found on page 65.
They love their bankers boxes, huh?
So as it relates to this, the state is asking that I simply instruct the jury based on the pattern instruction and not include that second paragraph. I had previously advised the jury with another paragraph that I was contemplating including, even if I took out that big paragraph that just said, at times, Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any manner. What's the state's position on including that, but taking out the paragraph you request to be taken out?
It's fine.
Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first
Tower would be a
paragraph.
nice touch. It really
I
would.
need the bailiffs to move the boxes away from his face. I need to be able to you can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something
Oh, he's losing his paperwork, guys.
He should take those
He
out
lost
now.
his defense case.
Otherwise, I need to be.
He lost his ability to testify. He's losing his materials. And hopefully very, very soon he's going to be losing his liberty for the rest of his life.
Mr. Brooks, do you have any position on the verbiage of jury instruction 70 on page 65?
Are you my accuser?
We lost Fort Brooks number 2.
All right, he's choosing not to answer, so I'll mute him again.
He's so low too. He's like,
Unfortunate
got a
that
fan.
he's decided not to
Like-
participate in
Oh, this morning he was hiding behind
I
a
agree
Bible
with the
for
state. I don't
like
need to
20
highlight
minutes.
that second paragraph. I will take that out.
Pretending
I
to
will
read it.
include in the paragraph that reads, at times.
Tear
however,
down this
court
wall.
is from another courtroom, period. This must not influence your verdict in any manner.
God, it's not even noon there.
Yes, bankers boxes need to sponsor you, dude, for sure.
The instructions
used a
that were
ton of them.
put on the last couple of pages include 325 impeachment of witness. Its prior conviction, the part about juvenile adjudication should be struck from the heading. And it should read, evidence has been received that one or more witness in this trial has been convicted of a crime. There were 2 witnesses that was applicable to. The remainder will be as is.
it's weird. The judge is actually
One witness
almost
for the
playing
state,
defense
one
attorney
witness
when
for
it comes
the
to
defense.
these jury instructions.
I just will add that if Mr. Brooks has any
She's
position
been
about this
going out of her
request,
way
he
to
should,
try and make sure the record's
he
clean
is
and
currently
clear, and there's
muted.
no
He can,
argument for
raise his
prejudice
hand and
because
I'll
she
unmute.
wants this to be as clean
Otherwise,
as
he can
humanly
pass a note to the
possible,
bailiff
given
or
what she
simply
had
tell
to
the
do.
bailiff who can then
And
tell
it's so
me, and I
easy to
can
get something like this overturned
unless
to
he
an
tells
appeal
me that I'm
because
gonna
it's like,
assume
he didn't have an attorney. He's like, so
made
you
a
got to be
decision
so
not to
careful
provide
if you're the
further
judge.
comment based upon
She went through about a
last
20-minute setting the
When
record
141,
with case law
I believe that's appropriate
just
given the evidence
before
that
she
has
decided
been
to close the
received. That's on
defense's case,
identification
which
of
I think was
defendant
totally
is an
appropriate and I
issue.
think was totally right.
Yeah. She, but
And
again, I think you're 100%. I think she's being extra
accordingly,
careful.
Unless there's a request
Yeah.
from Mr. Brooks to take that out.
But what is her alternative? If he
Request from you,
refuses to
sir, to take
participate,
141 out, I'll
he
unmute
can't
for that purpose.
do a heckler's veto and
That's
just
it.
shut
Found
down
on
the
page
case.
106,
It doesn't
'cause it's
work
at the
that way.
end of the
That's true.
instructions. This is the instruction on identification of the defendant and where it's at issue in a case. I believe it's appropriate given the testimony in this case. Do you have any position on that, sir? You are unmuted, so you can simply answer yes or no. No response. Then 172, circumstantial evidence, flight, concealment, I believe is appropriate given the evidence that has been received during this case. Yes, sir? You have been.
Am I unmuted?
You are.
So how long before you mute? As soon as I say something?
Well, before it's taking some damage, but it's still there.
Depends on what you say, how you say it, and if it's responsive to what we're doing.
Why do I have to be responsive to what you guys are doing?
Because that's how it works, idiot.
That's cute. That's cute.
Mr. Brooks?
Why do I have to be responsive to it?
And participate in what we're doing, which is discussing the jury instructions.
I'm gonna tell the jury the truth. That's what I'm gonna do. I'm gonna tell them what hasn't been told to me.
Mr. Brooks, as I'm gonna mute
You had a trial for that.
trying to discuss the jury instructions, not what you're going to say during your closing argument. I will get to that later. In terms of instruction 172, I'll instruct.
That
Madam
portends
Clerk to
ill
take
for his
out the
closing
heading
argument.
reverse. Should just say flight concealment.
You could have called anyone you wanted. The state was going out of their way to serve subpoenas for you.
I'm going to pull it up just as a draft. I'm not sure if there's anything that needs to be. So the pattern instruction talks about a chart. Is there any request from the state as to just keep that or modify that in any way based upon the evidence that was presented?
I think Kathy's talking about Edgecombe.
Because you
Edgecombe did it better. They at least made
maps
legal
which
arguments.
were received. I don't know that summary.
In theory, they were bad, but they existed.
I believe that was exhibit 141.
But that was received, wasn't it?
And there were some charts of the extreme dance team, the formation, and the dancing grannies.
Do you have the exhibit list, Madam Clerk? What are those numbers again? I wrote 141.
We're just looking for the extreme dance and dancing granny charts. 54 would be the dancing grannies.
Okay.
And 33 is the extreme dance team.
So 54, 141, and 33?
Yes.
Do you think the use of the word chart is correct, or should that be?
I would say diagram and maps. The court has allowed the use of diagrams and maps to organize the evidence.
The maps were evidence, though. What this instruction says is the court has allowed the use of a chart to organize the evidence and to assist you in understanding it. The chart itself is not evidence. It is a summary of some of the evidence that was permitted or presented. However, it is the evidence that controls. You should rely on the chart only to the extent that you believe it accurately and properly summarizes the evidence.
Then we think 154 should not be given.
It's in her discretion, essentially.
They were all admitted based upon how.
Usually they'll give you a lot of leeway, but he's gonna
regarding them.
blow that up real fast.
Typically, where that comes in is for use in openings and closings solely.
I don't know if you guys agree or not.
Based on evidence, and we anticipate those things coming in, not when there's been an actual document that's been admitted. So I don't think 154 is in that request. What about 152 regarding the view?
As I read that, that was given prior to the view, and I think that was appropriately given at that time. I don't believe it goes into the closing or the final instructions.
That was
I agree. The prosecution here objects, but usually you don't unless it's really egregious.
Get the party's position on that.
But
Once again,
it's going to be pretty egregious.
Any position regarding any of these last issues that we've discussed with as it relates to the jury instructions? Anything from you, sir, on the jury instructions?
Why? Why ask him?
It would be awesome if he just came back with something really intelligent for once.
He's not.
We'd all like fall
responding to
over.
the question.
I think he might be catatonic.
I believe that covers all of the issues that were raised by the parties then.
Oh, cool. That was actually really quick.
Final opportunity
Wow.
to tell me if you have any requests as it relates to the jury instructions, sir.
Oh, here we go. No.
Would you like to speak into the
Understand,
microphone,
sir, your
please?
objections noted. Your lack of consent is noted.
Okay, I don't see what's going on in here. So how's decisions being made without me being able to consent to it?
Sir, you forfeited your right to be present in this courtroom by your conduct, and you have not requested to come back.
Actually,
Yeah.
you put the,
Don't forget that.
So let's make sure the record is correct. You took a 10-minute break.
I did.
At which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been
Is he asking to come back into the courtroom now after business is over?
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the beginning. If I did not,
You did.
I'll put
I heard it.
For the record now, I was advised by the
So did
bailiffs
6,000 other
that
people.
you were requesting to stay in that courtroom. I certainly advised you prior to that if there was a time you wanted to come back in, all you needed to do was ask. You've done that previously. And even during this time, though, you've been incredibly disruptive at one point you were muted for an extended period of time and you were yelling so loud, sir. We could hear you in this courtroom. I couldn't decipher what you were saying. And I was also made aware that another branch could hear you. So you continued your disruptive behavior.
That's fine, because at the end of the day, I should be heard. I have the First Amendment right to be heard. So if I'm going to be constantly muted, the only way for me to be heard is for me to raise my voice.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to improve them. I'm going to take a break and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no. So how do you consent to anything?
Oh, that verdict form is going to be a
Are you
freaking
going to
book.
answer the question, sir?
But you can't force me to do it. You can't just say, I'm going to do this.
Sir, but you also can't stall the proceedings by failing to answer.
I didn't try to start the proceedings.
Snap.
I never held you in contempt. All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests.
They won't.
as
Nobody's
relates
going to take the
to
appeal. Are you kidding
instructions.
me?
I will work on making all the
Throwing
changes,
it on my desk. I'm throwing it in the trash.
finalizing the order, print them off.
He has a pretty decent case, though. It's like that's the worst part about it. I see a case
He
for
has
it.
been working on the verdict forms, which are of course
What,
But we'll
separate,
never get
closing your
there.
defense
being
argument?
approved by this court.
Yeah,
So those will be.
I didn't want to say I would win, but I would make it a fight, though. I think he has enough to make it a fight.
Mr. Brooks.
I think you
will
have a
take
prima facie argument.
a 90-minute.
Yeah, I'm not saying I can win the case from him, but it wouldn't be easier. Like we'd have like the fact that we had that one
What else
woman
are
that
you going
said,
to do?
well, you said you had the one woman that says he honked the horn and was trying to get away from the kids. That I would have brought out. I'd have had a psychiatrist talking about how crazy he is and how he lost control of the car. Like there's an argument here you can make. Obviously, this guy's insane. That's where the road we go down.
Yes.
Okay.
Yeah, Nate, if we put our heads together, I think we can come up with a halfway
I
decent
can
deal.
put on the record that I had the
I wouldn't
civilian
take
jury
it, but-
bailiffs
Oh yeah, I
provide
wouldn't take it, but I can make an
letter
Come up
argument.
with one.
regarding sequestration. There's an emergency contact form, so all of the jurors were made aware of
Man,
that.
again, you got really close to a
They
Brady
know
argument
that.
this morning.
Of course, once the
You
case
didn't
is
close it, but
all of the instructions are read and the parties make their arguments, and then there's some final instructions at the end, and the case goes to the jury. Obviously, only 12 of the 15 will be deliberating, but we can make a more full record of that this afternoon.
Thank you.
All right, we are in recess until 1 o'clock. I'm just instructing the parties to stay until the handout of the verdict, and then you can leave for lunch. Thank you.
Wow.
That
was
indeed.
By the way, yeah, Nate, Ben, Nate, and I don't. And
Hey there,
Nate,
Nate.
you know John. Everybody knows everybody here.
Yeah.
So okay, we're doing that, and a lot happened this morning. That was when you popped out, Nate, and I'm like, okay, it's jury instructions. I'm getting out of here. And for some reason, I held on a little bit. I'm like, well, it could get crazy. I'm glad I did. We had not one, but 2 box forts built. You just don't see that at jury instruction. My first box fort at a jury instruction conference.
I've never seen it before.
That was wild.
something. It was absolutely something.
And they just muted them. So I have the same thing about this.
Wow.
I'm gonna come back. So they're coming back at 1. I'll do another stream. I'll set it back up.
All right.
Okay.
And again, verdict forms is just. I mean, that's just basically part of the jury instructions. Oh, look at this! Look at this! And I can actually put one up without covering Nate right now. Lots of love for Nate. Lots of love for Ben. Lots of love for, well, there's lots of love for John, but then he gets the ginger thing, you know.
I get a lot of crap sometimes because people forget I'm a lawyer. I don't want the prosecution's case in this case is an easy win, right? There's no fight in that. You could just put any lawyer there and put him in a suit and go win the case. The more interesting case to me would be defending this guy. How would I defend this guy? And that's what I always talk about. You know, I don't want the easy one. I want to go fight, right? And I think the fight here, if this is, I think, a very interesting point about legal representation. Because if I was representing Darrell, I want him to do all the crazy stuff you're seeing. I want him to do that, right? Because in front of the jury, this guy is insane. I'm going to have a doctor call him insane. I'm going to have all this call him insane. I'm going to say he didn't know what was going on. He lost control of the car. Like, I think there are good arguments here for him to at least make it all muddy. Right, because my job is to make it money. It's not to now. I don't know if I'm going to win, but I would make it so after the end of it, you'll be like, "Well, damn, would they do it on purpose?" Because I'm attacking the intent, and I think there's a real attack on intent, and that's why you have him do all this craziness in court. Because there was a famous case in New York. It's called it was the peanut butter case. Have you guys ever heard of the peanut butter case?
Yep.
All right, so a guy goes into court. Right, it's a prisoner. He was in court, and he was about to go on trial for, I think, murder or something like that. So what he did was he went to the prison consignment and got peanut butter and put it on his butt, right, and squeezed it all in his butt. So we went into court. He's in front of the judge, and the judge is in it was a hearing about his mental state. So he stands up, he reaches into his thing, picks up this brown stuff, which is peanut butter, and licks his hand clean. And the judge looks at him and says, "This guy's obviously insane. Get this guy some help," right?
Right.
But that was exactly what he wanted to do. He didn't want the judge he wanted people to believe that he was insane. Now, obviously, they found out that he wasn't insane, and he went down. But that's what I'm talking about. That performance you can use in a way to at least move things along to get something in your favor. Now, I don't think this is going to happen with this guy. I think he's gone. But that's something I'm talking about.
Yeah.
Using all the tools in your tool bag.
I've been making the point because one of the issues is a DV case with the girlfriend that happened shortly before the incident.
Mm-hmm.
And I've been making the argument that if I had to defend this, gun to my head, it would be that he was so distraught because of the fight with the girlfriend that he was in an emotional state where he was not paying attention. And so you don't have the intent. So you get to maybe involuntary manslaughter, and maybe he sees the light of day again at some point. That's the best argument I could have come up with.
Yeah.
You didn't like his double jeopardy when he commits 2 offenses and he gets charged with when he gets charged with a second distinct offense that he calls it double jeopardy because that's what he was rolling today, repeatedly.
Yeah.
Oh, good Lord. All right. Well, thank you all for coming by. I'm going to close this down and set up a new one. I can't imagine it'll be long. I'll bet you I bet you they're going back at 1. I bet you they're out at 2:30.
Yeah.
The day.
Yeah, probably.
Give everybody a little time, and then tomorrow is going to be. Oh, it's going to be rough, Nate. Yeah, I mean, you're a prosecutor. Yeah. You've got to make that. There's 6 people died, 60 people injured. It's tragic. It's horrible, and you've got to display it.
Yeah.
Well,
I think. Go ahead.
All right, go ahead, Nate.
No, I don't think there's anybody in the world who has a doubt this guy's going down for top charges, top counts, and top time. Right? There's no doubt about it. It's going to be interesting to see his closing argument. That's I think is going to be the killer. Right?
Yeah.
What's he going to do?
I think he's going to immediately bring up subject matter jurisdiction. I think she's going to shut him down. He's going to throw a tantrum. And he's going to lose his closing arguments.
Yeah, I agree. That closing argument's going to be shut down. He's going to go venture off where he shouldn't. He's going to be shut down, and he's going to then go nuts and say, "I can't get a fair trial." Blah blah blah. It's all. It's going to be awesome to watch.
And then say that this wasn't fair, but none of it's going to work. But
by the way, not for nothing, the last several witnesses on the prosecution really set out a fantastic timeline between him mowing those people down and when they found him. And they did not publish it yet. And so that impact is going to be brutal.
Yep. Oh, he's got a tough one. All right, y'all. Thank you all for coming out. I'm redoing it at 1 o'clock. Anyone who wants to come on back, we'll see. I would never on any other trial say, "Oh yeah, let's go watch them work out verdict forms." But I am on this one because I don't know what's going to happen. It might be boring. It might be fantastic. Who knows?
You think they're gonna have the no box for not guilty?
We had 7,000 people watching jury instructions.
I know. That's unbelievable.
That's unbelievable.
I wouldn't do that if I was getting paid for it.
All right. I will see everybody soon. Thank you for coming out.
See ya.
Bye.